Well, good evening. Happy Friday to everyone. Friday, March 14th. Sorry for being a little bit late. And the chat was calling me out on it. Even EDB isn't this late. LOL. Yeah, time is okay. Yeah, I know, chat. I'm sorry. My apologies. My sincere apologies.
My chat starts hassling me about, have I caught things from Rob if I'm like 30
30 seconds.
seconds late.
I
They're
know.
like,
It's like,
oh, he's robbing it up here. And it's like, well, no, I'm just.
I know. Chat loves giving me a hard time. But you know what? It is what it is. Sometimes you have obligations, and sometimes those obligations involve some really interesting banter that goes on around the house. So some of you might have noticed that there's a poll that is currently pinned at the top of the chat. That poll asks a question. There's a backstory to this. So we have St. Patrick's Day that's right around the corner, coming Monday. For those of you in the chat who are Irish, I think I saw one of them. I had starred, or was it Laura? I saw you there. Irish person here can't answer the poll for legal reasons. That's fine. I'm not going to try and compel your answer. Obviously,
Irish people really kind of tend to have opinions about St. Patrick's Day.
They very much do. Either strongly opposed or strongly in favor.
I normally find the strongly opposed.
Because it's the commercialization of a very serious holiday. I get it. But
yeah, I mean, they don't really like their big holidays being reduced down to like, some guy in an alleyway throwing up green.
Or an entire city in the Midwest dyeing their river green. I get it. But kiddos, Mini Mischief 1 and Mini Mischief 2 Mini Mischief 1 mostly loves making leprechaun traps. True thing. She loves it. And I have a 3D printer, so I decided this year I wanted to print a trap. So now we have competing traps.
So I probably shouldn't send Mischief any of the little pull wire traps that set off a shotgun blank.
Nope, don't do those. Nope, none of your traps. Those traps are not friendly. Not at all. Because we want to catch the leprechaun, not maim the leprechaun.
Oh, they don't actually shoot anything. They just what is it? You're supposed to put a blank in them, and then it goes when somebody hits the tripwire, it goes bang, but it doesn't actually. So it's either an alert or it scares somebody. One of the YouTube channels, I think it was Tauflater Mouse, tested them with to see what happens if you put like an actual live shell in it, and it doesn't have any actual force.
So the purpose of this is just to make whoever's walking in your house defecate themselves.
Yeah, or
flee.
Yep, pretty much. I mean, you might just be you might be a little terrified if you were walking through somebody's house and then suddenly there was a bang from a shotgun shell.
And on the topic of the leprechaun trap, that raises a curious point. What do you think leprechauns poop if they were to get scared by a trap like that? Gold?
No.
4-leaf clovers?
Because it's obviously not gold. And the reason why is because leprechauns collect gold and nobody collects poop.
That's true. Well, sometimes cases collect poop.
No, the Commonwealth files poop.
So the debate started to occur because we were debating over whose trap was going to be successful. And Mini Mischief 1 said, leprechauns are not real. It's just you and mommy. To which I was astounded. 1, never. 2, mommy goes to sleep like way early, so there's no chance that could be her. Mm-hmm. So Mini Mischief 1 then decided we have a little device, an electronic device in our house, a Google machine. So she yells out, "Hey Google, are leprechauns real?" And Google's response was, "I'm more curious about the gold at the end of the rainbow." And she immediately, this is my future lawyer. She immediately pops up and says, "That is not an answer." Non-responsive.
Objection, non-responsive.
She goes, "I'm going to ask the one in my room." And I said, bet you know what that one's going to say too. And she walks upstairs, lo and behold, and she says, hey, Google, are leprechauns real? And the Google upstairs says, I'm more curious about the gold at the end of the rainbow. And she says, Google, I asked for a yes or no.
Oh, man.
So I believe she's watching now. So I put the chat up this morning or this
I
evening.
believe she's on partner track there.
That's what I mean. I think she's watching. So I put the poll up to actually prove to her that leprechauns are in fact real. And yes, we do catch them in our little traps. Well, we try to. And she said,
you should have warned us that she might be watching before you. But
then she says, why has no one said they caught one? I said, would you catch one if they gave you a pot of gold? No. I would. No.
I mean, I'm just going to say, I would totally let a leprechaun go for a pot of gold.
Absolutely. So. Unequivocally. Give me my pot of gold. I will let you go. I just want a successful trap. So we'll see if the trap is successful or not. How do
you think Elon Musk got so wealthy? Now that's a guy who could build a leprechaun trap.
He probably could. The automated, you never know. It's possible, I suppose, that the leprechaun being trapped is how he got so wealthy. Oh. Either way, that was the fun start to my evening. I loved it. Phenomenal. So yes, Mini Mischief 1, who are watching the chat, is very much indeed affirming that leprechauns are real. And don't you ever forget that, because here's the thing. They play tricks. And I don't think you want to be the victim of a trick. I certainly don't. I will be very, very happy to direct the leprechaun to whomever it is that believes he is not real. Namely, if you believe it's not real, I imagine some tricks might be happening. So, how was your week? Good?
It's been long.
Just long.
Just long.
Just long? I didn't have cords.
Well,
loved it. It was
I haven't yet been able to test out my flamethrower.
Why not?
Because it's actually a bit of a pain in the butt to get so it used to be that to get a burn permit for where I want to do it, all you had to do was just tell them that you were, like, you just go online and the form was literally just, I am going to be burning some stuff here at this time. And they'd be like, okay, cool. Now they've got like an actual application process thing. And it's like, and it wants me to answer questions that are like, how much peat is in the soil? And I'm like,
wait, what?
I don't think any, but I haven't actually done any like peat.
No, you know what you can do? Ian, you know what you can do? You can find a meteorologist who can test soil for you.
Yeah, if that was the kind of argument I was going to make, I would probably just drill a hole in my head and pour bleach in until the hurting stopped.
For those of you who didn't get the reference, that was a reference to last week's discussion about a meteorologist that apparently testified that the ground was rock hard. It's going to be an interesting...
Chat, you have full euphemism permission on that one.
You know what? We went through all the euphemisms last week. I think I caught myself saying, what was it? Take a look. It's in the pleadings. Yeah, about 6 inches down if you can find it. Last week was interesting. Lots of euphemisms.
I mean, Lolly's name was on the pleadings, so it was probably more like 4 inches.
We are 9 minutes in, folks, for those of you who are keeping track. Okay. So we have a bunch of stuff to talk about this week. Actually, I say a bunch of stuff, but not really. There's a lot of motions. I have read maybe one of them because let's just be honest, when like 45 motions get filed in a single week, when I have to file, answer, respond to all the motions of my own and my pleadings, these are the last priority for me to read through all the way, especially when a lot of these are just straight up pro forma.
I mean, basic. A lot of them are just kind of basic, right?
Oh yeah, a lot of them are basic. People are asking how Leo is. How is Leo the pup? Leo the pup is doing good. And by good, I mean it's been a chore. He is supposed to get 3 baths a week. I have been wrestling him solo in trying to get him bathed. It is not easy. There's more hair coming off him than I've seen, but we've been trying to meticulously vacuum. Oh my gosh, there he goes down the sliding to the hallway. Hope he's okay after that. I'm sure him slide all the way across the floor. It's interesting. My studio is in the basement. It's where I've been just relegated to the dungeons, which is, it's appropriate. But I hear all the footsteps throughout the entire house. So I can always tell when people are where they are supposed to be and are where they're not supposed to be. So Leo's doing well. He's a frustrating pup, but hopefully he's on the way to recovery. He's got to eat medication every single night. I have finally found the trick of feeding him medication. What do you do to feed the pups meds?
I just kind of hold the meds and hold a treat, and what do you call it? And they just eat them. So
I don't like you. I am astounded by this dog's capability of eating everything except the treat. Like it does not matter what I do. Just somehow I will wrap the treat. I'll wrap the pill in food. I'll douse it in food. I'll stuff it in food. I'll try to trick him. All of a sudden, the pill comes popped up. It does pill pockets. I tried them. I finally figured out how to do it, and it was slices of deli meat, and I would slice it. He has to take 3 pills. So I'd take the deli meat in thirds, roll 1 pill in one pill in the other one, and the third one. And what I realized with him is he's really smart, but he's dumb enough to look for the second treat before he finishes eating the first one. So if you trick him to thinking there's a second treat, he will try to devour that first treat as fast as possible to get to the second one. So the trick is you have one more slice of whatever you're giving him than the pills you have to give him. So you always hold the second one up. So he just eats that one because he's looking at the one you're holding up the second one. Then you give him the second one, then you hold up the just plain old piece of deli meat, and then you give him that, and it's just down it goes. It was the brilliant thought process.
I used to have a dog, Paddington Bear, who used to be very good at the sort of like eating around the eating around the treat there, or eating around the pill. And what we eventually did was so I'd hold up a treat, and he'd be like, and then I'd throw a pill into his mouth, and he'd be like, treachery. But then right after what he was going,
fair.
Right after what he was going, treachery, like, how have you done that? Then I'd give him the treat, and he'd be like,
actual treat.
Must swallow treat. The other thing I found worked is you just take the thing and like put the pill in peanut butter, and he just, because then he can't separate it out. And if he was really picky about it, because sometimes he'd get like really particular about, I'm not going to eat it, we would put the pill in peanut butter and let it sit, because the oil in the peanut butter will slowly dissolve the pill.
Oh my.
And so you just get very pilly peanut butter that he can't.
Sounds gross. Lisa is probably correct. I just qualified as an expert in Massachusetts to testify dog bites. Yeah.
Well, the thing is that it depends on which side you're on, because if you're on the Commonwealth, then you just skate right in. Whereas if you are Dr. Russell with like this huge, huge resume that, then they're going, well, now we need to have a 2-day voir dire. But this dog whisperer, he gets to just waltz right in because he freaking feels like it.
I mean, we'll get into it, because of the ones that I actually wanted to read, I think I wanted to read that motion to reconsider, which motions to reconsider by and large have like a 0.001% chance of ever succeeding. This one I'm curious to read because I haven't read it yet.
I know you've been buried in trial stuff, so I got to ask. Yeah. Did you see the Janet motion to reconsider?
No, I did not yet. Do you have that? Can I look at that just for joy and giggles? Because I need a laugh right now.
I will try to find that because
you did a video on it, right? So I'm not.
Yeah,
we're not scooping you on this at all. You're not scooping yourself.
Nope. What is it? It's got the. Here, I'll drop the link. It's so you can see the claimant's request for reconsideration, which is boring because she just rehashes all of her claims. But the more interesting one is the and I'll drop it into the private chat here. Is the what do you call it? The order on the request for reconsideration, because the Copyright Claims Board basically goes to war.
Oh, and okay. This might have just gotten out of the docket because I need a laugh. I need a laugh tonight, and a lot of the stuff I'm covering doesn't make me laugh.
Oh, it's so brutal in a way that's like, I mean, if I was getting a ruling like that,
smokes, 7 pages on an order denying reconsideration.
Yep. And you know what the fun thing is?
This is
they start off with, we could just dismiss this on the basis that it makes no new arguments in like a sentence. But we're choosing not to so that we can provide a full explanation and reasons and all of that. And I'm just like, oh, they're choosing violence.
Oh, this is going to make me laugh. Good. I needed this because a lot of this stuff does not make me laugh today. I was not happy reading.
Oh, they choose violence in the biggest way. And I mean, if I was one of her clients reading this, I'd be going, oh, this is a whole thing.
Yeah.
Yeah. And it was a lawyer I'd never heard of who's on the file. And I looked up where he works. He works at Benji's firm. That's the firm that is representing her on the defamation thing.
The one that we're like, how you're so intertwined with this? How are you repping her?
But the other one, the other fun thing is that when he files it, he uses not the law firm's email address because I'm guessing he was too new there to have his email address set up quite yet. But he uses his .edu email address.
No.
Which tells us that he has been a lawyer for all of like 8 seconds.
No.
Because he's still using his .edu. I mean, lots of lawyers continue to use their university thing for like personal emails.
Excuse me.
Keeping in touch
for
with
personal
friends.
Stuff. Or they create like a Gmail or Yahoo or something else. The .edu. Oh no.
.edu should not be being used, in practice.
Yeah, that's interesting. Every now and then I'll find like a lawyer on the other side that has like where they're in the pleadings. Their email is like at Comcast.net.
You get the old lawyers who are like
AOL. I saw one that was AOL. I saw one that was AOL.com. I am not kidding. That is still an email account. AOL.com apparently is still, I guess it redirects. I don't know, but my brain. You know what? Good.
I've seen some funny ones as well. There was one where the lawyer put in a correction to say, I put the wrong email on it.
Yeah.
And I'm pretty sure it was an email address that they'd had since they were like, 15. Because it was something like, Serio Killa, 69 or something.
No. No. Filing.
And they're like, please disregard the email address on my previous filing. It was I put the wrong email address.
Okay, so 2 funny stories. One, and it's in relation to this one with 70W's comment. How is AOL still a thing? Did I tell you about the interaction I had with my associate last week? So he was researching this case law, and this is my first year associate. He was researching this case law, and he said, yeah, I found this old case from the 90s. So first I was like, oh, ouch. Don't say that out loud. He says, I found this old case from the 90s. It's called America Online versus Jones. And I said, wow, okay. So that's one, it's not that old. Two, you sound like you're surprised. Do you know what America Online is? And he goes, no. And I was like, oh, no. And I then proceeded to ask everyone else in the office if they knew what America Online was.
No, Rob, we're old. This is like us, complaining about how the kids these days don't know how to use the phonograph or the button hook.
Don't understand. I was asking people in the office and said, you know what America Online is? Do you know what America Online is? The only other person was my partner who's in the office with me. That's the only other person who knew what America Online was. And I said, you mean AOL? And they said, oh, like AIM? And I was like, yeah.
Yes.
It has a name. It's called America Online. Like they used to send you these CDs so you could get online. America Online is how it was founded. That's the actual name of the company. Oh, I never knew that. That was a long time ago. Oh, I could have. It was a very upsetting day. It was emotional. I didn't deal with it well. It was very upsetting.
So, at one point, I had taken my phone ringtone, and I had set it to the old dial-up connection noise.
Oh.
And so my phone went off, and a group of lawyers, and like nobody knew what it was. And I was like,
and that's when you know you're in trouble. Like, yeah, I remember as a kid trying to, after curfew, when my mom and dad were in bed and I was supposed to be in bed, trying to sneak to get to the computer and like putting towels over top of the computer to prevent that thing from going, like, because it, no matter what the volume was of the computer, this thing blasted full volume.
There's an internal setting to disable that noise?
No, I did not know that at the age of whatever age I was.
You were way better at sneaking around on the computer late at night or way worse than I was.
So that was the one story. Second story is actually more akin to your like using the other email. So back when everything went to Zoom hearings, right? We had never done remote hearings before. This was a new thing in 2020. So very first appearance in bankruptcy court remotely, and you get this Zoom link. And this is back when Zoom, was paid for and it was brand new. We're sitting there going, how do we use the Zoom function? What is all this other stuff? And I get a Zoom link to join the courtroom, and it says log in with your email account. And my email account's automatically on my computer, so it like logs me in automatically. And then all of a sudden I'm in the courtroom. And my avatar for my personal email account was my dog. So I did not realize that the avatar that gets set for your Zoom account is automatic. Yep, there you go. Is automatically the avatar for the email account that you logged in with. So I joined a federal court hearing via
and you
Zoom.
had your I am not a cat moment
with a dog avatar. Let me tell you how fast that hand moved on that mouse. Holy crap.
Rob, it's okay. They just assumed that you were a furry and that it was a kink.
It was not assumption. It was a federal court hearing. There were like 30 other people, lawyers that I practice with to this day in this damn hearing. The judge was in the hearing. Everyone had professional avatars. Everyone had this other stuff set up. I mean, some people like looked like they were staring down with like the nose nostrils in the camera, but here I am with the avatar of my damn dog.
And you know what? everyone thought your dog was a good boy.
Adorable. Yeah.
Because of course your dog is a good boy, because, dog. So, nobody was upset.
169. Rob, I am not a dog, Your Honor. I was not a dog that day. 2/3 of them liked seeing your dog. I think they probably did.
Yep.
Generally speaking.
I know that there's a court proceeding where here in Alberta and I'm gonna turn my my dog
camera back
there.
on.
But the lawyer's cat jumped up on their shoulder, and they're like, "I'm sorry, Your Honor." The judge is like, "No, this is the best thing that's gonna happen today."
Oh,
I'm like,
I had an argument with the Court of Appeals, and we were doing it via telephone, of all things, telephone, right? So conference call, and there was this poor lawyer who was the case being argued before me, and it happened to be the day that the landscapers showed up at his house. So
oh no!
he's trying to make his argument, and there's a damn mower just like to the point where the judges were just like, "Hang on, counsel," and they made him pause so the lawnmower could go by, just so he could proceed with his argument. Oh my god!
Oh, that's rough. Yeah, I had a moment when I had to abandon being online and had to go to the office, and I was like, I want to work from home, but I can't today because they were doing construction on the neighboring property, and so it was literally like I was trying to talk, and then suddenly there's a building going down, or they're smacking a building with a a backhoe, and I'm like, all right, I guess I can't do court appearance. Like, I can't do a bail hearing while they're also destroying a building next to me. So,
and it's always when you need it not to happen. Like, it really is. Every single time. Every time.
Oh, 100%.
So, and you know what, everyone? This is just your notice. Just roll with it. Because everyone's been there at some point in time in their life. Just roll with it. They will make any... We've all been in those moments where it is just completely, like, paralytically embarrassing. So you just gotta kind of chill. Just like in Canton, Massachusetts, when every time one of the lawyers starts talking, you hear fire trucks going by. So, all right, let me catch up on some chats and we'll get to the first subject. I want to cover the Diddy stuff pretty quick and then get into some of the Karen Reed stuff. I might actually do the Jeanette Braun stuff before the Karen Reed stuff, just because we're going to need a little bit of a refresher and something to laugh at.
A little bit of a palate, what do you call it? An amuse-bouche.
Amuse-bouche. Yes, yes, indeed. All right, so Mama Bear of One, thanks for becoming a member. Ryan Man YYZ, soon. Thanks for becoming a member. And Ryan Man YYZ, giving 10 memberships. Thank you very much, Ryan Man.
That's
Christine, noting
that he's moving. It's not the soon isn't a threat.
I know. I figured. I think he clarified that last week. I think you weren't there yet. Laura Christine, thank you for gifting memberships. Phoenix, hello everyone. Hello to you, Phoenix. Mispronounced name, still one of my favorite names on YouTube. Don't worry, Rob. We know Runkle is responsible. No, Runkle. Ian is always waiting for me. He's like, huh, where's Rob? Oh, there he is. Yep.
It's sometimes fun because I'll go in the chat and be like, so
I have to say this
I'm
out
here.
loud. Sergeant Buck Cakes, Tainted Evidence. You like how I pronounced that one? I thought that was a good way of getting around that. Ian, can you update Rob on the name change for me?
I think that's just that they changed their name to that.
Yeah. I imagine that's exactly what that was. Icosaplex, what advice would you give to young leprechauns aspiring to enter the legal professions? To young leprechauns aspiring to enter the legal profession, never concede a point. Always ask the follow-up question.
Are you sure?
I know. There was someone I met with a potential client, and the potential client was like, my daughter just graduated from college. She's like, that's wonderful, great job. And she's thinking about law school. And I said, how can we dissuade her of that position? She just busted out laughing. But advice is to you want to enter the legal profession. Honestly, learn as much as you can about it. You got to love it. You really do have to love it to make it through and to be successful in it and to be successful for a long period of time. A lot of people I know that started off in law school no longer practice law. Actually, a lot of them never actually did. You actually have to love what you do, and it's important to actually find out what it is that we do.
I always tell Canadian prospective lawyers that the first thing they should do if they are thinking of law school is get the Constitution, and I don't mean just the Charter, I mean the full-on Constitution of Canada, which is long and talks about things like which branch of government gets to do which things, and read through it. And the thing I always say is, if you can get through it, like if you can't get through it at all, become a dentist, become a doctor, become a, whatever, because you will hate your life because this is going to be what you have to do. You're going to have to read contracts. You're going to have to read legislation. And so if you can't do it without hating your life, then you should know that before you go in and pick and I got to fix my focus here, and pick a different profession for you, right? But if you can get through it, like if you can sit there and you get to the end of it and you haven't been just glaze out skimming, but you've been reading it, you sort of understand it, and it may have sucked, but you got through it. Then if you really want to be a lawyer, you could do that, right? You'll manage.
I concur.
But if you get through it and you're full of questions by the end of it, like, wait, does this mean this? And does this? Then you might actually enjoy being a lawyer.
See, it's the enjoyment part. That's the fun part. But
there's so many lawyers who hate their life.
I might have looked distracted during the middle of that rest station. I heard all of it, but remember how I said I could hear everything from downstairs? There was a recitation from a very irritated mischief manager who's now standing in front of my computer, writing something, I believe, but who shouted and exclaimed, "Oh my God, what did you do?"
What did you do?
Not me. I was downstairs. I didn't do anything. It wasn't me that was being exclaimed to. Apparently, Leo allegedly needs his attorney very badly. What is he alleged to have done, honey? the whole thing, everything, all of it, all the floor. Yeah. Oh, so wow. It was a long day with the minis. Because, well, mischief manager made them a promise, and there's a little bit of backstory to get to here. Mischief manager made them a promise that there was a consignment sale being hosted by the church down the street from us, and said, great scam of getting everything out of the house, by the way, allowed the minis to go and pick all the clothes that they were willing to sell at the consignment sale, and made them a promise that if it sold, that they would get the proceeds from the sale. Great idea. Ended up getting all of the things out of there. So Mischief took the minis to the consignment sale to see how things were. And of course, more things came into the house while trying to get things out of the house, but that's how that math always works. And because they were there for longer,
I was going to say, I see the problem with this plan.
It's just always things in the house. It's never things. The net out of house versus in house never works in the way it needs to. But on the way home, because it was late, it was a vote in the car of the minis as to what they would get for food. And they got KFC. They got a bucket, big old bucket of fried chicken, bunch of sides. And that was what we had for dinner. I'm not ashamed. It tasted delicious. It was phenomenal. However, the bucket was apparently left in the center of the table when mischief manager went to go put the kids in bed. The center of the table that Leo, well, he doesn't really dive to the center. If you leave it towards the edge, you run risks. But apparently that KFC was a little bit too appealing to ignore. So there's KFC all over the entire floor. Just all the chicken, all over the floor, all over the first floor. The whole bucket is now.
I feel like you brought that on yourself.
I feel like I might have too.
My client is innocent in this matter. He was entrapped.
I don't know. There's angry photographic evidence. There's chicken all over this floor. I'm looking at my photos, honey. They're.
But whose job was it to safeguard? Not Leo's.
You know what? You make that argument. I'm not making that argument.
Leo did not have a duty of care.
You know what, Ian? You make that argument. I live in this house. I am not making that argument. No way am I making that argument. No.
I may have just gotten disinvited from the wedding.
No. Yes, me down on my YouTube stream while Misc is putting the kids to bed. But honey, who was it that was supposed to watch the food at this point in time?
Oh, I'm not saying you're absolved.
There's a firearm in this house, and
I'm not saying you're absolved. I'm saying Leo is absolved.
Okay. I was gonna say there's a firearm in this house, and I'm not about to be on the wrong end of it. Dang it! Stop. Hang on. I have. There's a. Oh God. Let's see if I can't pull this photo. Oh no, Leo, what did you do, my friend? Oh, yeah, there it is.
Yeah, free Leo.
Well, you're gonna have to do some persuasion. He needs a bond hearing, and we might need someone to post bail. Not sure. Let me see if I can't get this. Because
tell you what, I will post 3 dog treats. But upon his release, they are, of course, to be returned to my client.
No, that's not how that works. This is not released on your own recognizance. There is the culprit.
Hopefully he didn't swallow any bones.
No, it looks like it was caught before the chicken was completely dismantled.
Scattered it and he didn't even get to eat the stuff yet.
I think the "oh my God" yelled out loud occurred while he was in commission of the act.
Free Leo.
You can see him.
Free Leo.
Momentarily jailed. So you can petition for bond. Bond hearings occur 8:30 a.m. every day. Weekends, however, we hold over detention until Monday when the judge gets back in court. You can always go to the magistrate, but for this offense, you know what? This is a petty offense, so I imagine we can get released on own recognizance. But he'd have to post a good behavior bond, and I imagine some level of obedience training would be required prior to his ultimate trial. Do you waive reading the indictment?
God, no.
No, you want me to read the indictment out loud? How does he plead?
Not guilty, of course.
Not guilty. All right. I imagine you want to be appointed counsel.
This is a blatant case of entrapment.
Well, I wouldn't go so far as entrapment, but I imagine you want court appointment on this one.
I'll send you my fees.
Standard rates. No, you get AJC rates. You don't get to declare your fees.
I'm going to make an application for coverage at my full hourly because
fine.
This is going to be a complicated matter with very high jeopardy for my client.
Excuse me. Who are no. We're
going to need an expert in.
There's a Google camera in this room, so I imagine we can just subpoena footage and actually get the footage. Do you really want me introducing that, or are you going to somehow allege it was altered?
That video was taken in violation of my client's Fourth Amendment rights.
Living in the house.
You set up a covert security camera to monitor my client. Did you have a warrant for that camera?
I didn't need a warrant. It was in a common area in the home.
And I'm pretty sure you're in a two-party. Is it a two-party recording state in Virginia?
Knowledge is all that's required. Knowledge is all that's required. I know he knows it records because we talked to him through it because we're those owners.
No, he knows that it makes noises, but he doesn't know that it records because he doesn't understand the concept of a recording.
Oh, so we're actually gonna go that route. We need an evaluation done for his competency. I do not apologize for that distraction. I like the fact that we just argued bond over my dog.
And we'll do it again, folks.
We'll do it again. Oh no. The bond reconsiderations will continue until the dog is released.
Also, I'm pretty sure that your video might be inverted. And so
I just saw it.
Yeah. I've got some issues about tampering, and
I just saw it. Oh, there's artifacts in the video. It only recorded on motion. It skipped forward. There's no raw download. I mean, go ahead, take your pick, folks. We can make a joke out of just about anything. Oh, justice for Leo. Justice for Leo. For Leo's bail fund, likely. He was framed. The investigation was botched. Free Leo. There's no solo cups, although there is a tipped over KFC bucket.
I mean, the KFC bucket is just as good as for collecting evidence as the solo cups were. So
you know, it might be. I wonder if we can get DNA off the KFC bucket. Is that a thing?
Oh, I'm betting you'll get DNA. I'm just betting a lot of it will be chicken.
Probably get pig DNA. Who knows? You know, if you get
You're
pig
like
DNA,
horse. Why am I getting horse DNA, off of this?
If it's pig DNA, does that exclude the existence of chicken DNA on there? Or if there's no dog DNA on there, do I get to testify in Massachusetts as an expert? This is wild. Hang on, I have another exhibit. Where's the other exhibit? Oh my. Okay. Let's see. I swear this dog. It's not one thing, it's another.
I mean, that's part of the package of dogs, especially puppies.
It is. It very much is.
After Zora, Mrs. Runkle said that we will never get another puppy. We're just gonna get adult pound pups.
Yeah.
Part of the reason why is that I am bad at getting to sleep, but I'm good at acclimating to noises to sleep through.
Mm-hmm.
So, like, I can sleep on airplanes just fine, even though they're super noisy. Because I'm just used to airplane noise, so I can sleep just fine in them. I can sleep in cars. I can. Earlier, I went to have a nap, and we had a cleaner over, and I was like, "Hey, I hope you don't mind. I'm just gonna have a nap." And she's like, "Well, I'm vacuuming," and I'm like, "I didn't say stop vacuuming. I just said I'm gonna have a nap." And she's like, "Okay, fine. Like if you can sleep through it," and I'm like, "I don't know if I'm gonna get to sleep." Anyway, my head hit the pillow, and I was just out, because I was really tired. So it was just like, the vacuuming got done, and I slept through the vacuuming. Anyway, to bring this back to why Mrs. Runkle does not want another puppy, when the puppy wanted out, I, without like trying, just got really good at sleeping through the puppy barking to get let out. And she did not. So, yeah, she was not happy about that. She's like, dog barks in the middle of the night. And she's like, "Why are you not waking up?" And I'm like, tired.
By the way, chat is just chiming in with some real gems. I don't know if you've seen any of them. So can you tell, Ian, I'm going to put this photo up for about 20 minutes. Was it snowing on this day? Can you tell by the photograph if there's snow anywhere accumulated? I see crumbs, but was it snowing? The other thing is, the chat's now asking for a bite mold of Leo,
that looks like a high top to me.
The chat is just, this is the thing, guys. This is exactly why Yeah, one, chat is awesome. Two, the application of real world to not real world is phenomenal. Okay.
One of the things that's actually our courthouses do like a law day, and when they do, they usually put on a mock trial, and it's always a mock trial around like, you know, what is it? Goldilocks and the Three Bears kind of thing, right? Goldilocks is charged with break and enter
I
to
love
commit
these
theft.
trials. They're my favorite. Those are my favorite. It's just like when you and I were arguing over Bond over Leo, and the little things that you hear there. Law can be funny. It can be a lot of fun. And we cover some cases that are really ugly sometimes, but sometimes you gotta. Lindsay, yeah, that's one of my tables. That's a table I made that in 12 days because I had a stupid deadline and ADHD did the thing it did. So, where's a Leo law enforcement officer? Are you suggesting he would break the law and perjure himself? No. Okay. Okay. Was Leo searching for naughty pics on your phone? You guys. All right. Okay. So, with that distraction aside, I've got to catch up on some of these that are relevant and then get to the actual substance of tonight because we're 46 minutes in, and that sidetrack was entirely welcome because I needed that laugh, but you know what it is. Happy Pi Day. Love Friday Night Frenzy. Thanks, Martha. Happy Pi Day. 3.14. I love it. Linda Santiago, perfect Friday night. My two favorite streamers. Thank you, Linda. Sergeant Buchanan, Buck Cakes, tainted evidence. That said, guessing I'll be talked about a lot tonight. Oh no, you're gonna keep saying that. The thing is, I'm gonna say Buck Cakes until a certain hour, and then I'll go ahead and say the actual word. Fiona W, thank you for gifting memberships, much appreciated. Lisa, my daughter and I always open front door before opening the trap, just in case. Serious tricks were played on us every year. I have videos, and those memories are probably going to last forever. So congratulations, that's awesome. Sloth Life is 105 here in Scotland. Glad to catch a live. Glad to see you here, Sloth Life. Good morning in Scotland. Bop it. Peanut butter sticks for the pills, and down they go. We have a lot more to catch up on. Ryan Man YYZ. Leprechauns are much more my speed. I missed that reference.
Are you bad at mythology?
Yes. I remember a lot of things, Ian, but that is outside the realm of things that I remember. Probably because I never learned about it.
See, now you're going to get a case about Leprechauns, and you're going to be like,
Irish folklore, mischievous fairy, known as great love of drinking tendency to haunt breweries. Oh, it haunts breweries, pubs, and wine cellars? That is terrible. Does it steal the stuff? No, it's just haunting.
I mean, wouldn't you if you were haunting those things?
Fair. I steal the stuff as it is. No, I don't steal it. I consume it and pay for it every time. Mostly harmless fuzzball. Do you think Bev was texting her bailiff about Lolly having baby hands? Oh my gosh. Another reference to a case. That judge is no longer a judge. Crazy Cat Queen, I applied for criminology graduate school today. Everyone cross your fingers. We are indeed. And toes for me, please. Absolutely. Hope everything goes well. Amy Griff, here's a later. I had to go to TSC for dog foods, and the lady behind me was an exotic. Had an exotic, I imagine it's supposed to say monkey. Like the one from Friends, carrying it like a baby, buying pretty new harnesses and a leash.
Have you heard my monkeys? Monkey. Have you heard my monkeys rant?
No, my dad had a pet monkey, Mickey the monkey. He had a rant.
I have strong opinions on people having monkeys as pets.
Yeah, my dad had opinions on it too, and he had one and he hated it. Well, his dad had one and he hated it.
So
I imagine it's about the same.
Permission to rant?
Granted.
So the reason why you shouldn't get a monkey as a pet is because monkeys are primates and you are a primate. And monkeys sort of have this thing where they look around themselves and they decide where they fit on the monkey hierarchy.
Oh, no.
And if the monkey is... so the monkey will figure this out based on a couple of things. One, is it eating the good food in the house? And the answer to that is almost certainly no, because you're eating steak and fruit and salads, and it's eating monkey chow. So the first thing it will conclude is I am not, like, the first indicators suggest that I am not high on the hierarchy because I am not getting the good food. The next thing it will consider is, am I getting laid? And the answer to that should be no if you have a pet monkey. So it will then say, well, clearly I am not top of the hierarchy if I am, not getting laid, not getting the good food.
Mm-hmm. So your 2 nighttime activities are lame. Got it.
Its immediate sort of thoughts on that is that it needs to improve its status in the hierarchy of primates that it's there with.
Challenging.
So the way it will do that is it'll go to monkey society rules, which is that you basically pick a monkey that is higher up than you in the society, like higher up than it is in the society, and it will attack that monkey in order to beat the crap out of it to take its spot in the hierarchy. Now, monkeys are also smart enough to realize and to identify weakness in people. So they will tend to go after children. They'll go after the elderly. They won't go after, like, Rob. They'll go after the people who are vulnerable. So, and then they will attack using the most vicious attacks around, because monkeys don't really have this notion of, like, Queensberry rules of boxing. They're much more like, I am going to rip your eyeballs out and chew your face off. And yeah. So having a monkey in your house is basically like having a small time bomb for it is going to kill grandma. So,
I mean, I wasn't going to go that far, but I was going to go, yeah.
So the monkey might look super cute and so forth, but eventually it'll, like, eat grandma. And yeah, don't get a pet monkey. Do not. So, yeah. Assuming you like grandma still having a face.
Understood. No pet monkeys.
If you hate grandma, then
well, then we can have a different discussion. So
maybe you should just, like, tell her to move out, not that.
Yeah. Why don't we have a discussion with grandma instead of buying a monkey to cause? I mean, that's just one option. Ryan Man, YYZ, I have news. Got a job starting in April. I'm going to be designing machines for medical device assembly and manufacturing, doing the software for them. That's really cool.
That is.
That's like a pretty awesome job. Designing machines would be so much fun. Can I do that instead of law sometimes? I wish. The most jealous I've ever been is
because I don't think you have the skill set.
Take it easy. I mean, the most jealous I've ever been is when the 2 ARCA experts got up and Karen Reed, they're like, we built an air cannon. And I was like, but why can't I have that job? Because I don't know how to do that. I could probably figure it out. Torin, wow, almost 2 years a member, and the cat wheel is printed and put together. Still haven't gotten the cats to try it out yet. 3.5 foot diameter. Holy crap. Okay, Torin, that's quite the cat wheel. Jules O MN. I still have AOL email. I wasn't teasing you specifically, just other attorneys. Got us a hard soul.
Do you use it for work though?
You don't use it for work, right, Jules? No.
Do you, like, communicate with judges with the work email? With the AOL email?
Yeah. Got us a hard solar or solder. Took my 115-pound-year-old Mastiff for a walk. That's a big dog. A kid walks by with his dog. My dog got excited, ran over to play with dog while kid and dog ran away. Trucked me across the road. I have road burn on my arm. Dogs are okay. They can be. Sometimes they're really pain in the ass. My niece asked if I was really born in the 1900s. Oh, ouch. Oh, that hurts the soul. Lindsay, I still haven't used my Hotmail account. Oh, Lindsay. Oh, no. Megan, aka Megan's Autistic. I'm Aussie and I know what AOL was. Kimchi don't like Crosby, but the dog bite website ripping him as agenda-driven BS that push breed-specific policies and legislation, anti-pit bull. That stuff is why well-socialized and trained pit bulls languish in shelters. Just saying. I'm not getting into the specifics of different dogs or Crosby in particular. I think that I don't like his methodology.
I don't know about the website ripping him. I haven't looked at that. I just looked at his expertise appears to be in dog behavior when we need an expert in dog sharp bits, the bitey parts.
Yeah.
And I'm like, those are different things.
And his expertise is basically taking a mold and holding it up at distance to a photograph and saying this doesn't match. And for me,
let's look at it this way. Let's say we are trying to look at whether a bite mark in a victim was caused by a particular human. How much weight would you put on a psychologist testifying about a human's bites on, none, right? You would actually say that this psychologist who purported to testify about the bitey bits, you'd say that that's ridiculous, right? So yeah.
Or would you ever allow anyone in a criminal case with a human bite to hold up to a photograph, to hold up an impression made of their teeth, like to a photo and say that doesn't match or that does match? No. That would never be allowed. Never, not once.
I mean, and the other thing is that this is forensic odontology, which is largely discredited. So,
Chrissy Lee, happy Friday. I may have to leave before everyone drags my state, but this is for the treats for Leo. Chrissy, Leo will get treats. Maybe not tonight because he's waiting bond. Scorpion 142. I've been accepted in law school and figuring that stuff out. Got my pocket constitutional and Gosnady books. See, the Constitution is a big thing. I love just reading the actual Constitution and starting there before you go to all these things that you learn in law school. Like, start with the fundamental document, then start making the arguments in different positions, one way or the other. So, okay. Let's see. There's a lot to catch up on. I've got to get to a topic, so I'm going to save some of these.
You just got a chat here that's a reference to...
what, the Burgundy shirt fund?
I have a number of red shirts.
Yes, I know.
And so me and Mrs. Runkle had a minor disagreement. It's not like a fight or anything. I was just like, so I try to avoid wearing duplicate shirts, even though I've got I'm the sort of guy who ends up with I see a shirt that I like, so I'll buy 4. And so anyway, I had a red shirt the one day, and then I was grabbing a burgundy shirt, and she was like, people are going to think it's the same shirt. They're going to think you just don't change your shirt. And I'm like, but it's a different shirt. And she's like, but they won't be able to tell. So I was like, chat, can you tell, is there a difference between my shirt yesterday or is it the same shirt? And chat's like, no, it's a much darker shirt. I was like, cool, excellent. So today, I decided to play around with that. And I'm wearing a different shirt than yesterday, but it's the same shirt in that it's another shirt, but it's the same, I bought 4 of the same shirt. So chat is like, you are wearing the same shirt today. Are you wearing the same shirt today? And it's just I'm just testing the chat as to, but yes,
I'm not touching.
Mrs. Runkle was like, everyone's going to think you're wearing the same shirt. So
no, I'm not judging. There's no judgment. I trusted you to wear different clothes after you bathe and start a new day with different clothes. That's what humans do. Generally speaking, I do that often, most times, almost all the time, I think. So, Kimchi, thank you for clarifying. Agree that Crosby's inappropriate expert for this trial. Super Chat was RE Chat, using this one website as a source of truth for why Crosby sucks. Yeah, don't do that. That's we're going to analyze the legal arguments, the merits of the argument being made not outside information, allegations, or aspersions being cast.
He's probably perfectly fine in other fields, right? It's just this field where he sucks.
I'm just weighing the merits of him testifying here.
Yeah.
So, but thank you for clarifying that one. Okay, let's do this. We're going to swoop and we're going to get to the Diddy stuff because Diddy stuff is kind of quick. And that will be the fastest thing to get through because we're already, and oh my God, we're an hour in. Okay, swoop.
Sorry, Rob.
You know you're not.
No, I'm not.
No, you're not. No, you're not, damn it. Okay, so let's see. Shall we start with newspaper headline, actual legal pleading, or report from today's hearing? I think what I want to do is
I'm going to be agnostic on that one.
You know what? Let's go ahead and do this. We're going to start with the headline because the headline was what got put on blast first, which made me very curious as to whether or not there was any truth to it. Because, you know, headlines be headlining. So Diddy's trial is set to begin in fairly short order. Bless you. And you can already tell that the headline got ahead of everything else. Diddy, CNN destroyed the Cassie video, defense claims. That was the headline that started reading out yesterday. Pretty loud and bold on TMZ. Because TMZ be doing TMZ stuff. And I love this. They updated their article. Diddy destroyed Cassie video, defense claims. I wonder what that headline first read. I imagine it was not. It probably didn't have this after the comma in it. But you know what? We're not going to speculate. Everyone's seen the video, I imagine, because it's horrific and terrible and all of the above. And of course, there's an update here, 5:42 p.m. or 5:45 p.m. today, a day after this damn thing ran. CNN never altered the video and did not destroy the original copy of the footage, which was retained by the source. CNN aired the story about the video several months before Combs was arrested. The legal team tells TMZ our written and oral communication with CNN's counsel were clear. They destroyed the original video file they received from their source. So bombshell in the Diddy prosecution, CNN destroyed the only copy of the 2016 video in which Diddy is seen beating Cassie in the hallway of an LA hotel, according to new court documents. Okay. Filed a joint letter about the evidence. We're going to read that in a second. According to the defense, CNN purchased a video showing Diddy attacking Cassie in the hallway of the Intercontinental Hotel in LA. The letter claims CNN purchased the only known copy of the hotel's surveillance footage, uploaded that footage into a free editing software, altered the video, and then destroyed the original footage, even though it knew about and repeatedly reported about the federal investigation.
Did they say which editing software?
No, they just say and every reference to this has been a free editing software, which is
I'm like
very odd to me. Is there
why does it matter if it's free or pay? But also, like, what is the free software and why is CNN using free I'm like, is this DaVinci Resolve? Is this what are we talking here?
I don't know. Or did they just throw it into like Microsoft Photos and try to tweak the video or something? I don't know, but I guess the reference to free software is basically saying that there's no forensic value to the edits. You can't backtrace what edits were done. I think that might be what the defense is alluding to here.
I mean, that's sometimes true, but not always.
Yeah, correct.
Sometimes free software allows you to revert all the edits.
We're gonna see the judge's comments on this because it made me laugh a little bit. Because, you know, you guys, if you're not following, if you're ever interested in cases that are going on in the New York, in the Southern District of New York, and if you are not following inner city press, you are doing yourself a remarkable disservice.
Although lately he puts a lot of the better stuff behind a paywall, which is
I know, and that's a little bit frustrating, but I can't really blame him with the access that he's been giving or getting. So Leo is objecting to his confinement. Okay, so the defense claims that CNN alternately edited the footage by covering the timestamp and then changing the video sequence, which would make sense. That's a CNN thing. I would expect a lot of these 24-hour news cycles to do something similar. Put the salacious content back to back to back. Take the time away between salacious act from salacious act. Don't run the whole thing through. Okay, so that's what they did, I imagine. Defense claims blah, blah, blah. It also includes speeding up the video to make it falsely appear the actions in the video are taking place faster than they are. That's an interesting, I wonder if that's where they got that part. As a result, the CNN videos do not fairly and accurately depict the events in question. So that's the article. Let's take a look real quick. The court document was filed because that's going to give us a little bit of an understanding of what the heck is going on here. And then we'll get to notes on what took place today. Where are my files? All right. Load. So this is a joint letter that was filed yesterday by the two parties in this case to the judge that's hearing the trial, Judge Subramanian. The parties respectfully submit this joint letter in response to the court's order dated March 12th, 2025. A 24-hour turnaround ain't bad as far as the joint letter is concerned, directing the party to outline the issues the parties believe should be addressed at the pretrial conference scheduled to proceed on March 14, 2025 at 2 p.m. So, voir dire. How are we going to conduct voir dire?
Badly.
Maybe if I whisper. Oh, nope. You heard that. He is very upset. He can hear me talking, and he's getting mad that I'm talking. He's like, "You're talking. I'm in my confinement." Hang on, let me text Michelle. Oh, never mind. I don't have to text her. I hear her walking the stairs. So, voir dire. How are we going to select this jury? The government respectfully requests the court commence voir dire prior to the scheduled trial date, with the intent to present preliminary instructions and opening statements to the jury on May 5. So the government wants this case moving quick. They want voir dire to take place 2 weeks prior. They do not want anything except a very, very basic questionnaire going out to the prospective panel because they don't want specifics getting out into the public before the trial commences. Because they actually want the panel to be rather broad. You would imagine the government doesn't really care if people end up on the panel that know about the case. They kind of want people that want to know about the case because why not stack the deck in their favor? That's what they want. The defense, however, and the government also wants this to be done so that the trial proceeds without an interruption by the July 4th holiday, which makes sense because the government wants to get their case in chief done and they want to get this to the jury without the jury being sequestered over the holiday or interrupted, because juries tend to take that out on one of the parties and the government don't want to play that risk. Defense is saying that they want the jury to begin on the day the trial is supposed to start. Why not? With 2 written questionnaire days. They want the summons to issue 300 jurors, complete written responses, and they want this questionnaire to be specific. They want a lot of information because they want a narrow scope of jurors who don't know the information about the case at all. Go figure. That's not surprising to me at all. And of course, the defense wants a break in the trial because any break in the trial plays into their favor. Evidence gets forgotten from one day to the next. They can decide if there's a break in trial, what to put on the next day. It helps the defense. The jury questionnaire, they go back and forth on their respective positions there. The defense discovery. Here's where we get into the relevant discussion. I think it was here. Yeah, that's the case. Because it's going to be there. Okay, so we got a couple pages. We'll be quick in the recap. To date, the government's made 25 discovery productions to the defense. However, the government's yet to receive any of the defense. So this is a reciprocal discovery issue. The government prosecution saying we need reciprocal discovery. Defense hasn't given anything. Government is saying the defense issued several subpoenas, got subpoena returns, but hasn't given anything to the government. I'm not really sympathetic to the government in that regard. Generally speaking, I don't think the defense should have to give very much. And I think the defense, who's already behind the 8 ball as far as the investigation is concerned and the trial, should be given more latitude in what they produce and don't produce. So the government's saying, give us back what we asked for. And then they're saying, at the very least, you got to give us what you received in response to your subpoenas. They're saying it's unfair to us. I don't believe that the state is accorded a right to fairness. I know that the law reads differently than that, but I have a very different
I don't think they should be accorded an inherent right to fairness.
The law, the judges like to give it to them or hold the defense to account. I just think the prosecution has a leg up on everything. The defense, however, says as follows: they are fully aware of their obligation under Rule 16 and they intend to comply with them and never suggested otherwise. In fact, during a recent meet and confer, the defense explicitly informed the prosecutors that we would be complying without, I guess it's supposed to say with our Rule 16 obligations. To the extent the court is inclined to impose a deadline, I imagine they will be, for additional disclosures, we would suggest a deadline closer to trial after the government has produced its exhibit list, as has been done in other cases in this district. This is smart. I like this. This is a good move by the defense. Cite to specific cases that this district has done before. Make the judge feel comfortable about doing it here. So they say the government's got the burden of proof. We shouldn't have to put on anything until the government tells us what the hell they're going to put on, because we don't know what we're going to rebut.
Did you say government?
Government. I didn't say government. 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 Okay. Nevertheless, the defense will produce the material it's obtained through its subpoena tomorrow, even though we do not presently intend to introduce this material as part of the defense case in chief. So one of these subpoenas went to CNN. Specifically, this production will include a subpoena response, a subpoena response by CNN with copies of surveillance footage from the March 16th Intercontinental Hotel incident. The defense has confirmed through a forensic video analysis of the CNN footage the government provided this court and of the footage provided by CNN in response to the defense subpoena that all CNN footage was substantially altered in significant respects. This includes covering the timestamp and then changing the video sequence. It also includes speeding up the video to make it falsely appear that the actions in the video are taking place faster than they are. As a result, the CNN videos do not fairly and accurately depict the events in question. Here's a little preview of some of the argument they're going to try and use to keep it out. Finally, the defense has confirmed that CNN purchased the only known copy of the hotel's surveillance footage. Damn it, CNN. Uploading that footage into a free editing software, altered the video, and then destroyed the original footage, even though it knew about and repeatedly reported about the federal investigation. Footnote. I don't think there's anything in this damn footnote. Just the article. Got it. This will all be the subject of an upcoming motion limine regarding the CNN derived footage. That's clever use of phrase. Look at that. The CNN derived footage. We will be disclosing the subpoenaed materials of the government, so it will be prepared to respond to the defense motion on the subject. Here's a question for everyone in the chat, and this is one that might be a little more rhetorical than most. In the Karen Reed case, when we're talking about video and video being doctored allegedly or manipulated or edited, timestamps and sequencing really, really, really matters. Very much so, because the allegation is that someone else caused damage to the car, the taillight. So the position, timestamps, sequencing, very, very important. In this particular footage, is there any dispute that it's Sean Combs on the video and that he's in the hotel and that he's engaging in the behavior he's engaging in, whether it's sped up or not? So if there's no dispute that its video itself depicts Sean Combs and Cassie in the 2016 incident, I can imagine what a judge is going to do.
I'd argue it should be excluded if there's no non-sped up copy.
Well, guess what the judge says?
Judge says it goes in, or judge says big block of redaction.
No, hang on. The judge is not going to preview the judge's ruling on the issue because we don't have the briefing on it yet. But from the perspective of what a judge is going to look at, you get it some of an understanding of how judges view arguments like this. I get that there's certain parts of this, right? So maybe let's say it's out of sequence. Okay, then play the video in snippets. Play different snippets of the video in the correct sequence. Can you resequence it? Oh, and then the other part of this is this entire part of this joint motion or joint letter is redacted. So I imagine there's something in there dealing with victim identification or the videos that we've seen as being redacted in this case. But as of right now, we are slated to have all motions in limine briefed before April 11th. And we want the final pretrial conference April 14th. And that we are going to be ready to go for trial on May 5. So that's where things stand there. And let's go ahead.
I will try to move the move my things so people can't hear my keyboard.
I didn't realize that. I couldn't even hear it. I was because I was just talking. It's honestly, it was like a court reporter was transcribing what I was saying, so I didn't mind it at all. Like,
I will try to mute. Sorry, folks.
Okay, so intercity press reporting from inside the courtroom because, again, federal court, and in federal court, no cameras, no nothing. So we have reports by individuals that are in there who are credible at reporting things. Intercity press likes to report in form of transcription as much as it can. So, and by transcription, I mean loose transcription of what happens because people be talking fast. Combs, lawyers chatting. Combs is led in by U.S. Marshals, tan uniform, MDC jail. His hair is silver gray.
So he dyes it, and he hasn't been able to get access to hair dye.
I know that was kind of a little bit of a blow there, huh? But in terms of not court reporters, but courtroom. What's the word I'm looking for? The sketch artists. Remember the sketch artist that did Sam Bankman-Fried dirty?
They look like they drew him from the wrong end.
I mean, it's not the nicest photo I've ever seen. It's pretty brutal. Like,
also, they make him look like he showed up topless.
I mean, it's a tan jumpsuit. It's not the worst.
It's hard to tell where the jumpsuit starts and his neck
begins. I will say this is far better. This is you can tell it's Diddy. This is a far better depiction than it was of Sam Bankman-Fried. You remember those courtroom sketches? Where were those? Hang on. I got to find one real quick. Sam Bankman-Fried courtroom sketch. Because that sketch artist. I mean, that sketch artist
just basically started drawing hair and then eventually was like, oh, I can't draw hair forever, so I got to, add a face.
Bring the chat back to a good old memory. How about this one? Y'all remember this one? Sam Bankman-Fried.
Or that one where he looks like he's a Super Saiyan.
That one was something else. Or the
why do they always draw people like they're a turnip?
I don't know. It was then they did Carolyn Ellison. I don't know what these courtroom sketch artists have.
It looks like she melted in court
against all these criminal defendants. I mean, so when I'm looking, and now view this in context. So that's Sam Bankman-Fried, right? There's Diddy. Diddy's looks a lot better now.
No.
It's still bad.
He looks like a piece of driftwood with lips.
The gray, when they said his hair had grayed, this sketch artist like did him dirty and was like, no, we're just gonna drill all this white with a couple of patches of like pepper. All right, so there's your visual 10 uniform MDC jail. His hair is silver gray. All rise. Judge Subramanian. Good afternoon, Mr. Combs. Good afternoon. You seen the superseding indictment? Yes. Do you want me to read it? Nope. Waive public reading? I do. So there's a not guilty plea. So the judge then moves on to this. I propose administering jury question hours April 28th, 29th. Judge splits the baby, says we're going to do it before May 5th. We're going to get these things out beforehand. Come back for voir dire on the 5th. So we're going to start voir dire after having questionnaires circulate a few days before. We'd like a sequestered voir dire. That makes sense. They don't want people knowing who's on the veneer. We'll do that. Next is defense discovery. You'd like to do something like the Eisenberg case. See, I told you this is something that's good. Give the judge cases they know. And then they say, here's a present. I give you back what you have. Then the judge moves on. USA, so looking to the prosecution on the CNN video, is there an issue with it? Are you going to use it? Mr. Angefilo says there's a motion incoming. AUSA says we want our subpoena returns or their subpoena returns provided to understand what they have. Our view is that the video is direct evidence. The judge says we do not have the original security video? ? The AUSA, we have the CNN and a recording of the original footage. That's interesting. What do you think the recording of the original footage is?
I don't know.
What a weird way to phrase it, right?
Yeah. That does not sound like, yeah. I don't know.
Like someone duped it before someone duped it before they put it into the editing software. That's what that sounds like.
Something like, or like somebody recorded the screen.
I don't know, or it's not a forensic. Maybe it was the security guy who pulled it. I don't know. Very odd way of phrasing it, right? Huh. Okay. Judge says, will you confer with the defense to agree on which video will be used at trial? You're not trying to mislead one, are you? Of course not, Judge. Why would I ever try to mislead the court or anybody else? Combs' lawyer. A source gave CNN the hotel footage. CNN ran that footage through a free editing software. Our expert says that changed the nature of the action, making it up to double time quicker. There you go. There's the argument. It's going to say that it doubled his speed. He has lightning fists. They took things out of sequence, took out the timestamps. Interesting. So the lawyer says, we say the video is deceptive. We'll bring that before your honor. Judge, a possible solution would be to slow it down or put it in the right sequence. You may want to block it, even if it's totally accurate. Try to come to a compromise. Okay. So the judge is like, go back, confer. See if I really want to hear this argument or not. Judge says, why do we need two sets of motions? We proposed to file March 19th, so ordered. We want to identify the people in our 404B relevance issue. Could you extend your order about the enterprise letter to that? A little bit back and forth. Nothing really big. Tease up motions practice. It's about all the different victims and the people that are close to the case. Then they're going to say the Combs lawyers want to know all the names of all the people. The government doesn't want to give the names of all the people because, again, reasons. Let's see. And then the judge says, I'm going to order the government to provide the names on Monday on attorney's eyes only basis. Motions practice starts Wednesday. There we go. Next pretrial conference, April 25th. If we need more after that, we can do it. Government intends to produce 3,500 on a daily basis. Oh, just supplemental discovery. I saw some nods in the back. That's fine. USA Steiner, so the AG or the attorney for the government, They have told us they will not seek a trial delay. Well, that's what they told you. That's what they might have inferred. It does not necessarily mean that's what they're going to do. And then Combs' lawyer, like a boss, comes back and says there's no application with regard to the trial date. We recently came into possession of a lot of medical records. We want an expert on prescription medicines. So he's basically saying, Judge, I make no promises. That's what that means. So we've got a question on CNN footage. So we're going to keep our eyes out on what that motion says. I'm very curious what the argument is going to be made on that. And I do imagine that Sean Combs' team, Diddy's team, is going to fight pretty damn hard to keep that video out. Having seen the video.
Oh, I mean, they're going to do their best. They're just going to get. I suspect the judge is going to want to get it in very much, but I mean, I would argue that it's been sped up. How much do you slow it down to be the right amount to slow it down? And it's going to be misleading to the jury, because if you speed it up, then it looks much more aggressive. It looks much more violent than it is, and it makes it look worse. So,
and it's going to come down. I think it's going to come down to, because the defense is going to try to exclude it. So this is going to come down to burden shifting on who's got the burden to prove what. So the defense has the initial burden to seek exclusion. Well, no, that's not true. The government has the initial burden on production. Defense has burden on exclusion. The burden on exclusion after production burden, because the production is basically saying, I have this, it shows this. So government satisfies the initial burden. Now it shifts to the defense to exclude, seeking to exclude it. The defense now has to prove to the court why it should be excluded. And I think as part of that, the defense isn't going to be able to say that it's just sped up a little bit or sped up in some speculation. They're going to have their expert file an affidavit as to exactly how much, if they can determine how much it was sped up from original speed. Because, and I think that's going to end up being the turning factor. If the expert can say, it's a double-edged sword. If the expert can't say how much it was sped up, the judge might say, well, you haven't satisfied your burden on exclusion. If the expert can say it was sped up 2 times, then the judge might say, all right, then we know exactly how much to slow it back down. So I think that Ian's gut is right, but my gut is right there too. The judge is going to want it in just because it's pretty significant evidence, and no one really refutes that it documents what it documents. It's just whether it's sped up and whether it's misleading and whether that should result in an absolute bar of the evidence coming in at all, or whether there's some way of presenting it in a non-misleading fashion. So I'm curious. But if the Diddy teams gets that video excluded,
that's going to be a huge win for the Diddy team.
Holy crap, that's a win. Because that video is horrific. Also, CNN, what the hell? You come into possession of the only copy of this video, which, you know what? Good for you for getting the jump on that and getting the scoop and buying it. I have no qualms.
But then you don't preserve it?
But then you don't preserve it.
Yeah, that to me is insane. And quite frankly, I'm wondering if CNN could have some criminal liability on that.
Basically, especially if they knew there was an investigation going on.
That sounds like destruction of evidence to me.
It kind of does, obstruction, especially if there's an investigation, especially if CNN were placed on notice that they might be in possession of content that the AG was looking for. So I don't know. If I'm a newsroom and I somehow get a reporter coming back to me and says, hey, so I've got a guy at the Hilton or the Intercontinental who can get me the raw footage of this, I'm saying, okay, raw footage, you go into the secure file. You can duplicate it and mess with the duplicate if you want to create the news headline or whatever the hell you want to do with it. But you can play with the duplicate, because I'm leaving this raw footage right here. And because I imagine the second this thing airs, I'm going to get a very curious request from the U.S. Attorney's Office asking me for a copy of this fucking tape. So, and the question Laura asked, would the hotel not have the footage? I believe two things. One, hotels and most establishments have overriding video storage where it writes over itself after a period of time. Two, some of the allegations from the original indictment read that
suggested that he tried to purchase it and eliminate it himself.
Yeah, tried to purchase it and have it destroyed.
So it might have been somebody snuck a copy out before it.
While in the process of destroying it. And I imagine the government's going to come back with an argument that will say, of course, we don't have the original because he paid for it to be destroyed.
And that might be a compelling reason to allow the edited.
Yeah.
You know, it's like, well, you don't get like, you know, this is on you if you tried to have it destroyed and you were unsuccessful. Like, hey, you know, maybe you should have preserved it rather than having it destroyed.
Exactly. If all we have is a derivative, and even if the derivative is misleading, but I can demonstrate that you actually procured the deletion or destruction of the original such that the only thing we have is this because of what you did, you better believe a judge is going to allow me to produce whatever misleading content remains. And they're going to say, you get to own and eat the consequences of that of your own action. So I'm very curious. This is going to be a very big motion and very, very hotly contested because Diddy knows how important this is. The government knows how important this is. And both of them want this video front and center in this trial. Because once you show a jury this video, they're looking at Diddy in a very different way than they were when the trial first started.
Mm-hmm.
Like we've talked about how defendants even showing up on that side of the aisle or behind that table, there's the deck kind of stacked against them. You show a jury that? Good luck climbing out of that hole. Because it's very likely not happening. All right. So to recap, factually, where everything stands, there is a video. Everyone acknowledges it. They acknowledge the video came from CNN. The government says we have a copy of the original and we have the edited version. Diddy says we can prove it was edited. This is the video showing Diddy doing all the things in the hotel with Cassie, which is like shoving her.
This is the video showing Diddy did it.
Yeah. This is the video that resulted in his stupid non-apology.
Also, Rob, close the poll.
Oh. Poll is closed. I can tell Mischief that mini Mischief that of the where was this? Come on. Of the 2,200 votes, 41% of you said yes, leprechauns are real. 36% yes, but they only live in Ireland. Only 22% of you said that they don't exist, which shame on you. Either way, so this video is kind of, I don't mean to say it's the ball game for the prosecution, but it kind of is. The second this video gets shown, Diddy screwed in every respect. At least one of those charges is getting convicted.
I mean, it's not the whole ball game, but it's a big ball.
Yes.
And they really want to ball Diddy with it.
They very much want to just do terrible things to Diddy with this video. But the question is whether the video itself can be turned back into a version that's not misleading as the defense says, or whether the prosecution can prove that the defense procured the destruction of the original video. That's the debate. So we'll see what happens with that. It's going to be very, very, very interesting. But that's one of the first legal arguments that I've seen back and forth in this case that I'm very fascinated in. I was a little fascinated in the jailhouse stuff and the messing with the notes, but this one I think is a lot more interesting in whether this video comes in or not. So abuse is abuse, slow or fast. That's a lot of people are going to have that opinion, and but I'm also with Ian on this one. the prejudicial effect of showing something sped up that shows conduct that's a lot more egregious might outweigh the probative value of showing the video at all. I don't know, but if there's a way to correct it, or if it was procured by Diddy's own doing, it's coming in one way or the other. Dude got the Van Gogh treatment. All of them did, in a very savage question. Volkus says, random question: have either of you guys tried matzo sticks? Like matzo, like
as in like deep fried cheese?
Mozzarella, or like matzo balls, like unleavened bread? Tried all those things. I think they're both good in certain circumstances. So I'm going to say yes. Jack Campbell, as Runkle is ranting, I'm sitting here eating Friday steak and potatoes with a beer and thinking about it. A moment fumbled with a girl today. Guess we are primates. Well, that's a fair thought. You get back up, you have a good day the next day, you go back and you say hi to that girl again. Just because no one should have Michael Nesmith as a pet, monkeys should not be kept as pets. Monkeys shouldn't be as pets. They're going to get in a lot of trouble. Victor Mann had to order fried chicken after that story. Congratulations. Hopefully there's some remaining, because there's none remaining in this house. I'm going to, you know what? I am not dissuaded.
No,
if Leo took a bite of that, I will eat the rest of it. I have no shame.
Now I want KFC.
Yep. Amy T, I worked at a junk mail factory and sent out all the AOL CDs. We're all old. Amy, there's a lot of people who curse your existence right now for all those AOL CDs that went out of the mail. Those, you remember those things? They came like every week. Amy Z, my best friend's having a 40th birthday, St. Patty's Day birthday tomorrow, and one of her coworkers moonlights as a leprechaun, and she wanted to hire him, but thought it might be an HR violation to ask him. Oh no. Avoid the HR violations. Have fun elsewhere under different circumstances. Don't risk your job. Book Dragon KSC. I spent all week working on a writing competition. My brain is fried, and all I needed was laughs. Hope you got some. Analytical Blarney, scattered chicken, no body evidence thus far, other than chickens already killed, not Leo's problem, and self-defense, because dogs be dogging. The defense rests. Now, the defense had better arguments than that. Opposite of amnesia, my chocolate lab, Ruby, turns 1 on Tuesday. She sends this bond money for Leo. Solidarity. A non-mouse. KFC bucket, attractive nuisance. What precautions were in place? I don't know. I apologize. The Leprechaun did it. Prove me wrong. I mean, I've got the burden of proof to prove he did it beyond a reasonable doubt. Circumstantial evidence is pretty strong, though. Tamitha, we need EDB as a judge. I imagine she'll serve in that role. Donnie B has Haas long to pick up poop in the house. Tell them the dog never went in the house. The Karen Reed jokes are solid in this one. Angie, free my boy Leo. He ain't do nothing wrong. He's free. Sandie, where can I send his bond? You just did. Red pointless pen, ring camera footage of Leo tossing the chicken parts. It's there somewhere, probably. Pop it. Leo's bail money. Deanne says free Leo. Tumwater Troy says, what a dog who steals snacks.
Purchase of Leo of equal or greater value?
What's a dog who steals snacks? A pup perpetrator. I see what you did there. And Belle Feinstein, hubby says Leo's entitled to part of everything in this house. Hence, the chicken is partly his. Since when? Under what law are occupants to the home entitled to things within the home?
I'm sorry, he's not just an occupant.
He's a family member. So.
I'm pretty sure he's the he's in charge now.
He might be in some cases. He is. I mean, the man. I have to give him a bath. I have to bathe this thing. So yeah, sometimes he is. Kim Chi, every dog is always a good dog. Free Leo. Chat will post bail if needed, says Rosebud. Did they read him as Miranda rights, says Mama Betts. Free Leo, says Kim Chi. Dina Kawaji gives 1 membership. Thank you, Dina. Analytical Barney says KFC ringworm. Leo absolved. Humans problem.
Wait, KFC ringworm? What?
Leo has ringworm.
Do you think the KFC is going to help or hinder that?
I don't think it is. It's not going to. Probably not going to help.
Now I'm looking at, like, probably not KFC because KFC is not good. But I'm looking at, like, Mary Brown's maybe.
Where it was.
Which is also Canadian, so even better.
Mischief just posted something saying, oh God, I can't find that because, hang on, I got to find the article. She posted something about the leprechauns being real. Remember the article that went around about the leprechaun?
So, Rob,
was,
you're not going to object to the third-party defense of a leprechaun did it?
I mean, I am going to object to I mean, no, I'm not conceding third-party defense. You have a pretty substantial burden to clear if you're going to try and...
I believe we just established that Leprechaun is a possibility because you established that they exist and that they are prone to mischief.
No.
And pranks.
You need more than a mere possibility. Mere possibility has never risen to a level sufficient to allow you to produce third-party culpability.
Except you've also stated that those leprechauns are present in your residence and are known to play pranks and tricks.
The traps are not out yet. No.
I mean, why would you set traps if there's no possibility of leprechauns?
You have failed to carry your burden of proof in order to present third-party culpability. In no circumstance is this going to be. If I were to grant third-party culpability,
the guy who's setting out traps for the leprechauns now denies that the leprechaun is a realistic possibility.
No, not a realistic possibility. It's not just the possibility. Possibility is not enough for you to present that defense. You don't get to say in speculation that the possibility that someone broke into the house and did the thing that was not the dog is enough to actually present that to a jury. That's misleading to a jury.
Except if you also have the indication that they were present there.
Okay. But here's the thing. There would have to be some tangible evidence that they would be present here, not just the fact that I have a trap out for them, which means that I have a suspicion they might be present. You have to have some tangible evidence they were here. Is there a pot of gold? No, I don't see one. Is there leprechaun poop?
I don't have to prove it. I just have to raise it as
you have to give some affirmative evidence beyond just speculation.
I don't think it's just speculation if we're at the point of setting traps.
No, that's still speculation.
And I'm sure that by the time trial day runs around, that there will be additional evidence to confirm the presence of leprechauns.
Oh, come on. So I'm going to give you my witness list, and then all of a sudden you're going to come here with a production of... No, that's not how that works. Plus, I think there was a sketch artist that caught the leprechaun. Remember this one? The sketch artist? Yeah, no third-party culpability. Not here.
Sorry, Rob. I'm pretty sure...
you know what? I'll let him out on time served. I will let him out on time served. He can go out on time served.
But we're not putting this on my client's record, given the substantial possibility of a third-party leprechaun.
Sorry. This is a Schedule 3 misdemeanor. Nope. Class 3 misdemeanor that stays on his record. You do not get to expunge this.
Then I'm afraid we're going to have to run the leprechaun defense.
All right. You know what? You clear the hurdle with the judge on the leprechaun defense. I dare you. You see if you've got enough to go forward on this one. I'm going to file a motion limited to preclude you from introducing everything in reference to the leprechaun.
So who's the judge?
Canoni.
Shit. I could have video evidence of the leprechaun doing it and she'd still preclude.
So for those very confused by several things that just took place, third-party culpability defense is one of the things we were discussing. As far as what you could or could not produce, third-party culpability is what Karen Reed is allowed to introduce in her trial, which is basically saying some other dude did it, sod it. Some other dude did it, someone else did it. and you have to clear certain hurdles beyond mere speculation that this actually transpired. It has to be motive, opportunity, has to be some other circumstantial thing. But there was a while back where this made the news, which is where that sketch came from. Let's see. Can you guys hear the audio?
For St. Patrick's Day.
I forgot this news bit. I forgot this existed. Laura, how annoyed I'm about to be? Probably very, but Leprechaun, you know, it could be a crackhead. You know what? The crackhead broke into my house and tossed the bucket of chicken all over the place and then framed Leo for it.
No.
I'm just gonna say there's probably overlap between Leprechaun and crackhead. Because if leprechauns exist and crack exists, then surely there's the overlap of the leprechaun on
the
crack.
Leprechaun. That's completely logical. I'm with this man. I am 100% in his camp.
I am not, because there is a pot of gold anytime you what do you call it? Start digging up trees. Have you looked into tree law?
Oh yeah.
Do not mess with trees, because there's a pot of gold.
It just comes out of your pocket.
It comes out of your pockets, and you give it to the owner of the tree.
That's fair. That's fair.
I don't think this guy's got gold in his pocket.
Yeah. What I just click into a story from several years ago that I'm still convinced was a pun, and but third-party defense, third-party culpability. You're not getting away with that. Kanoni says, I mean, I know that people say that it's allowed, but
I mean, she allowed it in
the Reed case, the third-party culpability.
Yeah, well, I don't think they allowed a specific person. But in this case, I'm not pointing the finger at a specific leprechaun. I'm just noting the general possibility of a leprechaun.
A leprechaun did it.
That you can't exclude all leprechauns.
I'll allow it.
My client's getting acquitted.
No, I don't mean to do that. Yeah.
It's a good thing Leo's got a good lawyer.
You know what? We'll replicate it. You make the argument, and I'll just breathe heavily into a microphone, just like Jess Canoni.
There we go.
Yeah, and then we'll have ambulances scheduled to drive by every time that one of us starts speaking in either any motion argument, and then I'll take it under advisement at the end, and we'll get a ruling within a week or two, maybe. Probably not favorable, but we'll just have to see where it goes. So, Mary Lou Crafts, I'm sorry, mostly dead from migraine, but thanks for the distraction. Hopefully that was a fun distraction. Ian, tell Rob about the house hippos.
Are you not familiar with the house hippo?
We've talked about this one before. Yes, we have. Why my brain is stopping right now, because we've talked about this several times.
Let me just see if I could pull up the video of the house hippo.
Did you ever watch the movie Along Came Polly?
No.
No? With Jennifer Aniston and Ben Stiller. A terrible movie. Well, it's not that terrible. But the hippopotamus. But you are not a hippopotamus. You are a zebra. Never mind. The reference is missed. I had fun with that reference, but that's just me. Nine Inch Nails Gal.
Find it here.
Nine Inch Nails Gal. Oh, come on. You brought delicious chicken into the house, did not share with Fur King, and want to charge him for taking what was his. Entrapment, 100%. Yo, I see where your loyalty lies. I do. Astounding. Book Dragon KSC. I spent all weekend working a writing competition. My brain is fried, and I needed the laughs. Side Quest 101. New member. Thank you. Michael J. Money, KOC, but it's Pie Day. 3.14 is a day for pizza. Decisions were made.
I mean,
I regret
not
it.
wrong. I ordered fried chicken.
Lisa, I'm so old. Walter's in charge of switching the pocket parts for my attorney as a paralegal. The pocket parts for my attorney? I am lost. Walter is in charge for switching the pocket parts with my attorney as a paralegal. Lisa, I wish I understood what that was. I do, promise. I lost it. I guess that reference went right over my head. Holly's Hobbies at my house, we call it the dog tax. Free Leo. Baby steps. Leo's a family and protector. He has earned the chicken. Give him hugs for me. He's getting hugs. Don't worry. He gets hugs, and then I have to sanitize my arm so I don't get ringworm from the dog. That's the sad part. He's not supposed to get pets, but I can't not give him pets. So I've just been very meticulous about washing carefully after giving him all the pets because I can't see him go without love.
Don't pet that end. Pet the other end.
I pet the end that has the snoot that poops. Okay, so
Zora does this thing where when she wants her butt scratched, she'll come up and she'll do a circle around, aim her butt at you, and then she'll back up.
So Mischief has not.
Zora.
Mischief has not read the mood of the chat, honey. We are not going to win this defense right now. Not in this chat. Not in this forum. The jury pool is tainted. So Mischief says I actually poured some KFC gravy on his dinner tonight, so that's what I get for sharing. The chat is going to say we didn't share enough. They're going to say we gave him a taste, but not the actual food. So we this is a biased jury. We need a questionnaire to circulate at least 2 weeks prior with some very vague questions. We need to get a better veneer than we have right now. So. Okay.
I disagree. Sorry, you are not entitled to a favorable jury. You're entitled to motion
transfer venue. Motion transfer venue. Problem is, any venue I transfer to on YouTube is gonna be not favorable to me. It's gonna be favorable to Doggo. This is bullshit.
Excellent defense counsel.
What happened to a fair trial? Fair trial. Oh wait, I'm the government. I don't get a fair trial by my own arguments. Damn it. Oh no. Everyone's gonna say it's gonna transfer to EDB's chat or your chat.
Oh yeah, I'm sure
either way.
You know what? I'm okay with that.
That's what I mean. I'm not gonna get a fair trial, but I'm the government, so I'm not gonna get a fair trial, period. Okay. So let's move on to another thing that hopefully will make us laugh. So swoop. And double. Wait. Why did that not work? That was weird.
I don't know, but the videos aren't playing for me.
It's very odd.
They just kind of.
Shall we check in on Jeanette Braun?
Oh, yes.
I want to read this so bad. Original docket. I don't care. I want to read this really badly.
This is like watching a courtroom hunt or an administrative body, I guess, hunt a lawyer for sport.
Let's do this. Why don't you get people caught up to speed? Because here's the thing. A lot of people are going to have a question because I haven't covered Janet yet. I haven't covered Janet.
So, Jeanette Braun, who we call Janet because she told the internet that she hates that, which you never do. You should never tell the internet what pisses you off because the internet will then proceed to do that forever. So anyway, she told the internet that she hates being called Janet, and so therefore, that is how that is. So, but she got into, or one of her clients got into an internet beef because she didn't like being called a TERF. And so she gets in, she gets upset. People start criticizing this and also start criticizing Janet because Janet starts sending down takedown requests and so forth and strike requests. And so anyway, this turns into a whole shit show. So she calls in a wellness check against another creator, Caffeinated Kitty, and then later sues a bunch of people for defamation. So that's sort of the beginning. But she also gets upset that two of the people she's suing, the girlies from the Do We Know Them podcast used a 1-minute clip out of an 8-minute TikTok that she put up in order to basically say her arguments are bullshit. Yes, this was related to Lauren the Mortician. So she is claiming copyright infringement against the Do We Know Them podcast girlies. She takes that to the Copyright Claims Board. She is represented by counsel.
Wait. You've left out some very funny details. Can I fill in just a few funny details?
Yes,
a few
absolutely.
funny details that were left out.
Yep.
In the call that was for a check, she said, "I am a federal attorney."
Yes.
So
she
said, "I am a federal attorney," in the call, rather emphatically, trying to browbeat the person who was on the receiving line of the call, saying, "I'm a federal attorney and this person's not well." And that just is not something that any attorney ever says out loud. You are not really a federal attorney. You might practice in federal court, but no one really says that. That was one. And then she loves going on the internet, like it's her favorite thing in the world, and talking about how she is a copyright lawyer, that she knows all the copyright.
And she's she sort of pitches herself as a social media lawyer. So
Yes.
Copyright, trademark, and also understanding how social media works. Because if you look at the Shelley Sahi case, where Sahi loses out of basically inability to defend, but anyway, if you look at that one, what is it? What is it? She basically did a whole lot of like advising on like how to do all that. So that was a whole thing there. So she thinks she knows the internet, notwithstanding the fact that she keeps blundering about all of that. But what do you? It's just baffling. But she hires counsel for this, and so she's a what is it? What is it?
So this is the very example. Let me do this because it was making some people uncomfortable. She's the very example of, "I am putting my money where my mouth is. I make this claim that you have violated my copyright. Therefore, I am now going to sue you." And the entire internet saying, "I dare you, I dare you, I dare you," and she says that, and then proceeds to get her ass handed to her. Right?
She's up against the girlies who are self-representing. So
they were pro se?
They were pro se.
Holy crap. So
you've got a self-proclaimed IP lawyer with counsel going up against two smart women, but just ordinary whatever. And so she proceeds to get clowned because the Copyright Claims Board is like,
bullshit.
Your application, like you didn't do any of the procedural stuff correctly. And it's like, on one side, you've got the Do We Know Them podcast girlies who, okay, it's understandable why they would get it wrong, especially because they're filing second and they're kind of cribbing off the first side. But you would think that team IP lawyers should know this.
No.
So there's that. The second thing on that one is that you've got, so they lose badly. Janet loses. They say that it's not a close case. They say that it is very clear that, in fact, this is, this is fair use. It's a very clear case of fair use. So, Janet cannot leave well enough alone. So what does she do? She files a motion for reconsideration. And she basically argues all the same shit that she argued the first time.
Now, the good news is we don't have to read both in order to get it, because she argued it the same thing again.
Yeah, well, and we don't even really need to read a request for reconsideration because it's just not all that interesting. But it's just arguments she already made, and she's like, but you guys are wrong. And that's not how a motion for reconsideration works. You have to say, like, did they make an error of law? Or did they, or is there some change in the law? Did they make some big mistake on the facts? Usually this is something like, the court found that one thing happened before the other, and that's not true because, it's the other way around.
No, see, here's the thing. I just read her first paragraph, and I disagree that we have to read none of this. I have to at least read the first paragraph.
Fire it up. Bring it up.
Sandie is reminding people, please take a moment. Please hit the like button. Please do. Please hit the like button. It shows people you like the content. And consider subscribing. It's like right there. Just ding, like. And then also go to Ian's channel and subscribe to him, because he puts out way more content than I do, and he's been covering this case. And his saga of the Janet saga is just start to finish, full breakdown, epic. We're just at the end playing a little bit of laughs, because paragraph in the motion to reconsider. First of all, motions to reconsider or request to reconsider goes back to the judge that made the original determination. So one, you're either setting up an appeal, and therefore you're trying to lay out some legal issues that you think you need to more fully argue so you can appeal it under those issues. Or two, you think that the judge may have misremembered one thing and you can clarify that might persuade the judge to make an alternate ruling. The percentage of these that get granted is exceedingly low. I have won one of these in my entire career. And it was because the judge had misremembered something and I had some pretty freaking solid case law I brought at the end. These do not win. So you're very cautious in how you bring these, because you're going back to the judge that made the ruling. Argument. This is the paragraph I wanted to read. In its final determination, the CCB ruled in favor of respondents Jessica Vasquez and Lily Marston, finding respondents' secondary use of claimant's copyrighted work, the work, to be fair under 17 U.S.C. 107. In support of its ruling, the CCB found that, and this is the part that I started to laugh at, she quoted the ruling and not in a way that I think she probably should have. Maybe don't quote the judge's strongest words that hate your case back to you. So the CCB found one, the first fair use factor at the quote, at the very least, strongly tilted, end quote, towards respondents. Two, the second fair use factor was, quote, neutral, or at best, slightly weighted against fair use, end quote. Three, the third fair use factor weighed, quote, somewhat in favor of fair use, end quote. And the fourth factor weighed in favor of respondents as, quote, there was no meaningful evidence that the use of the work affected the market or value of the work, end quote. Claimant respectfully argues that the CCB materially erred, and this is the part I made a laugh at, in its findings regarding the first, third, and fourth fair use factors. Let me tell you how many times a judge is going to say that I was incorrect in my findings of fact.
The only time I've seen this like succeed on a finding of fact thing is something like the court says
a date was wrong.
Yeah, the court says A happened before B, and it's very clearly that like B happened, you know, and like they just misread the dates, right?
Yeah, example, like on Monday this happened, and it turns out that the allegation was like on April 25th, and April 25th was a Tuesday. Like, oh, I correct myself. April 25th, which was the date that I found, was a Tuesday. So on Tuesday this occurred. So, shall we see? I'm nervous. Order on request for reconsideration. Ian, in your experience, how many pages are orders that deny reconsideration?
Like 3 sentences.
They usually say motion was filed, or no,
Yeah,
they say
claimant
decision
made
was made,
or claimant lost.
decision made. Yep.
Claimant files for reconsideration. Motion is denied.
1, 2, 3. Judgment, reconsideration, denied. That is it. This is 7 pages long.
Oh, yeah.
Oh, and we start off with a full recitation. Oh, this is going to make me happy. Okay. Claimant Braun IP law, Braun IP, or claimant initiated this copyright infringement claim against respondents Jessica Vasquez and Lily Marston, collectively respondents, on December 11th of 2023. The Copyright Claims Board, the CCB, or the board, issued its final determination in this proceeding on January 31st of 2025, finding that for respondents and dismissing the claim with prejudice, means don't bring this shit back here. As a review of the final determination reveals, this case was not close. Oh my God. Oh my God. Shall we highlight? I want to highlight. It's going to make me happy to highlight. Highlight. Let's do pink. Okay. This case was not close. Respondents' use of the work at issue was textbook example of fair use. Oh, this can make me thrilled. Many of the arguments made by claimant were utterly meritless, some to the point that they undermined claimant's credibility. This is the first paragraph.
This is so brutal, isn't it?
Wow. Moreover, the board did not take a cursory review of the work. The board used the same definitions as final determination. Oh, so they even slapped her there. The work at issue and its use, but watched both works several times, detailed in the final determination's factual history section, which lays out respondents' clearly transformative use of the work for criticism and commentary.
Yeah, they say we can search for the orb. Sorry. I just talked in the wrong thing.
Did you talk away from your microphone? Please tell me you talked away from your microphone.
Nope.
Despite the detailed nature of the final determination, on March 2nd, oh no, claimant filed a request for reconsideration. A request for reconsideration of a final determination must identify a clear error of law or fact that was material to the outcome or a technical mistake. Just as importantly, the request shall not merely repeat any oral or written argument made to the board as part of the proceeding, but shall be specific as to the purported error or technical mistake that is the subject of the request. Notwithstanding that rule,
I'll keep mute on when I've got to type.
A 12-page brief rehashing the greatest hits of the party statements claimant filed in the written testimony phase. Holy crap. So basically said you brought your greatest hits and it sucked. The board could simply deny the request on that basis. The arguments continue to be meritless and no clear error of law or fact or technical mistake is presented. I thought you were speaking hyperbolically when you said they said we could simply deny it, but we're going to go further. They literally say we could simply deny it. However, rather than merely denying the request in a cursory order, the board will briefly rehash why the episode so obviously qualifies for fair use. Oh no. Oh no. They say for educational purposes.
The educational purposes is brutal. It's like we're gonna teach you a lesson.
Oh no. It's so bad. Oh no. Okay.
It's like you, the IP lawyer, are gonna learn something today.
For a detailed factual history, including the many ways in which the allegedly infringing work, the episode, uses claimant's work to critique it, See the final determination at pages 2 through 7. They cited 5 pages. Suffice it to say here that the entirety of claimant's work depicts Braun IP's owner, Jeanette Braun, sitting at her desk, recording on a computer or phone camera a generally factual recitation of her position in a dispute with an internet personality named Becca Day. Braun did not like that Day accused Braun of filing, quote, false copyright strikes, end quote, against, quote, small creators, end quote, such as podcasters and influencers on the internet, so that she can get things her clients do not like taken down. Braun's defense to Day's accusations in the work is highly semantic, that she does not file a copyright strike, but rather files a request for a strike. Oh, shit.
Semantic can be read as bullshit.
Yeah, bullshit. That she doesn't do the copyright strike, but rather files a request for a strike, and the online service provider performs the strike. I remember this fucking video. I remember this video where she said this. Oh my God. The tea and drama referred to in the work was squarely in the wheelhouse of respondents' podcast. In the course of discussing the Day Braun fight and Braun's position related to that dispute, respondents played a 1-minute clip from the 8.5-minute work and spent approximately an hour commenting on and critiquing it. Completely. Oh my God, this is great. Completely dismantling all of Braun's arguments in the work, as well as expressing their displeasure with Braun's tactics on behalf of her clients. Oh my God. Oh, they said the respondents were 100% right. Respondents also discussed at length the concept of fair use and additionally argued that Braun engages in hypocrisy by sending takedown notices against instances of fair use and material potentially not protected by copyright, even though she has previously educated the public in other videos she has published that a fair use analysis should be made before sending a takedown notice. Oh my God. This is phenomenal. On December 3rd, 2023, Braun IP sent a takedown to YouTube regarding the episode, and respondents sent YouTube a counter notice. As previously noted, YouTube's opinion does not factor into the board's decision, but YouTube unilaterally made the decision that, regardless of whether Braun IP filed a copyright infringement lawsuit concerning the episode, they would not take the episode down because YouTube independently determined that the episode's use of the work clearly fell within the category of fair use. They literally said YouTube be idiots, but YouTube got it right. Wow. Oh, we're 2 pages in. How does this get worse? Related to potential damages and market harm, Braun IP stated that it uses a standard licensing agreement for videos it creates, for which it charges $7,500. We're after 2 hours. Are you fucking kidding me? $7,500 to use or license one of her videos.
Oh, it was such a stupid claim. That video sucked so hard. Nobody would pay $7,500 for it.
Wow. So that would be akin to, what is that? Let's see. $18 hours of my time, 17 hours of my time. So you're making a video that was 8 minutes long and you're valuing it at 17 hours. Cool. It was unclear what types of videos the licenses covered and whether those videos were anything like the work. Although Braun IP now admits that the licenses were for very different types of videos, as the work was an outlier to Braun's IP's typical material. Oh no. Fair use. Rather than trying to identify a specific, quote, clear error of law, end quote, the request is dedicated to re-arguing the fair use principle, including the first, third, and fourth factors. Again, it would be easy for the board to deny the request on that basis alone, since every point made by claimant was already made by her in her party statements. However, it will briefly explain the fair use factors again, with the hope that Braun IP might change its tactics in the future. With all due respect to the CCB, for some reason, I don't get the impression that the tactics are going to change. I think that there's a disagreement, and maybe Janet Braun thinks that she knows better about copyright law than the board that just denied her claim and smacked her down. So, for non-exclusive factors. What? Sorry. I was having too much fun. Say what? You're muted. You were saying something that was productive. And
I'm saying she is bad at everything she does.
I mean, she's good at drawing attention to herself. That's something. Although I don't think she's trying to do that. I think she's trying to do the opposite.
I mean, for her suggestion that like she's not filing false complaints, it's like the copyright board thinks otherwise.
Yeah. Space Cat, is the judge doing this because Janet tried to say they were wrong? No. The judge is doing this because Janet didn't get the fucking point. Like, he gets smacked down in the final judgment and Janet responds, and then the copyright board is coming back and saying, I'm sorry, do you read? That's what the copyright board is saying. 4 non-exclusive factors are considered when analyzing a fair use defense. 1, the purpose and character of the use, including whether such use is of a commercial nature or is for non-profit educational purposes. 2, the nature of the copyrighted work. 3, the amount and substantiality of the portion used in relation to the copyrighted work as a whole, how much of it you're using. 4, the effect of the use upon the potential market for or value of the copyrighted work. All right, are you diminishing the copyrighted work's value? As to the first factor, claimant misunderstands the esteem that critique and commentary, explicitly called out in section 107, holds in a fair use analysis. Oh, geez. Misunderstands the critique and commentary. Braun IP argues that the commercial nature of the podcast outweighs the transformative use of the work. No. No. Yep. Nope. Never mind. Copyright board's on top of it. Right there. Next sentence. Keep reading, Rob. But the fact that the podcast was commercial carries little weight when the purpose of the use was to critique the claimant's work. It doesn't matter if you're making money. If I'm ripping your thing apart, that's the purpose. You misunderstand. It ain't about me making money doing it. It's about the fact that what I am doing is transformative in that it's tearing yours apart. As the Supreme Court has said, quote, the commercial or nonprofit educational purpose of the work is only one element of the first factor inquiry into its purpose and character. And if commerciality carried presumptive force against finding of fairness, the presumption would swallow nearly all of the illustrative uses listed in the preamble paragraph, including news reporting, comment, criticism, teaching, scholarship, and research, since these activities are generally conducted for profit in this country. Yeah, basically, anytime I'm pulling up some criticism, reading the news, giving a recitation of information, even giving lectures, I am doing that arguably for compensation. It doesn't mean that I lose protection over analyzing your work. They do a case cite. Claimant quotes the syllabus as opposed to the actual decision. Oh, geez. Ruh-roh. So the syllabus is a little paragraph that they give in the very beginning that gives a synopsis of what the case said. And here's why what the copyright board does is a slap across the face. One of the lessons you learn in law school is to always, and absolutely every single time, read the opinion you are quoting.
Cite to the case, not the wrapper of the case.
Read the opinion you are quoting, because there is nothing that could be more embarrassing and get you in hotter water than misquoting a case or saying a case says something that it does not. And those little syllabi, or the very beginning parts of the case, the wrapper of the case, as Ian described it, generally give a very condensed version of what it was the case found, and oftentimes doesn't actually go into the analysis or anything about the specific findings. When you quote the syllabus, you are doing a bad. You do not do that. The court did not find the syllabus. The syllabus is basically the Cliff Notes. Don't quote the Cliff Notes. So, Janet quotes the syllabus, and then the court goes on for the proposition that when a secondary use is, quote, transformative to some extent, end quote, the first factor can still weigh against fair use when the transformative elements are outweighed by other factors, such as the use's commercial nature. However, the Warhol opinion noted that criticism and comment, parenthetical, the purposes of respondents' use in the video clip, and parenthetical, quote, are the sorts of copyright or copying that courts and Congress most commonly have found to be fair uses, and so may guide the first factor inquiry, end quote. Basically, you cited something that actually says the opposite of what you're trying to say. Okay, court goes on. Compelling reason to conjure up the original borrowing from it. Yeah, when you're commenting on it, you kind of have to pull the original in order to give fair commentary. Respondent's use of claimant's film clip was precisely for the purpose of commentary and criticism targeting claimant's work, and therefore highly transformative. Oof. Oof. In short, respondent's use was not merely transformative to some extent. Oh, they quoted her quote. Oh no, it is precisely the type of highly transformative use that is fair even when done for profit. All right, there's bitch slap number like 16 if we're counting them. Braun also raises a strange argument. Uh-oh. Let me tell you how many times you want a judge saying, you raise a strange argument, counsel. Usually never.
Strange is never a good thing to hear.
No. Mr. Runkle, that's a strange position to take in your case. Why? They raised a strange argument while citing some of the cases finding fair use already cited by the board that the episode, quote, recreated, end quote, the work's creative expression. What? Wait, what? How does one recreate the creative expression? Like regurgitating the same words? Like you created it and then I just used it as a script to say the same thing. Right? Is that the argument? Okay. As already stated by the board, respondents used the 1-minute clip to accurately report on the story they were discussing and to allow their viewers to understand the context of the story and their critiques of Braun and of specific content in the clip. Basically, the board is laying out a foundation for if you ever want to critique anybody in the future, this is how you properly do it. This is perfect. The, quote, recreation, end quote, argument is just a different way of stating Braun IP's meritless argument in prior written testimony that the clip was used for its original purpose, which was to provide Jeanette Braun and Braun IP's law's side of an online dispute between her and another content creator. Oh my God, there's meritless again. You know what? If these two were not pro se, this would have been an award of attorney's fees by a lot. Like I'm guaranteeing the only reason they didn't get fees is because they didn't have them, because they did this without counsel. As stated in the final determination, respondents used it for the opposite purpose of any possible creative expression in the work to go through a detailed critique of Braun's content and give reasons why Braun's side of the story did not hold water. There's no doubt that this use falls into the category of criticism and commentary. Braun IP does not seem to have learned a basic lesson from the cases cited by the board. Oh, hang on. We're gonna teach a lesson, and the board's gonna teach a lesson, and we're gonna highlight the lesson being taught while we're teaching it. This is freaking phenomenal. Let's change the color of this one because we need to learn some more. Because this is great. Because this material makes me happy. Braun IP does not seem to have learned a basic lesson from the cases cited by the board. Namely, when one video is used to present a point of view and the second video uses the first to criticize that position, the use is, quote, fundamentally at odds with the original purpose, end quote, of the first work and therefore inherently transformative. And then the board proceeds to cite 1, 2, 3, 4, 5, 6, 7 cases from the, where's this one from? You've got Southern District of New York, Southern District of New York, Second District Circuit Court of Appeals, DRI, District Court of Rhode Island, Central District of California, U.S. Supreme Court, and the U.S. Supreme Court. Cool. As Braun IP does not challenge the board's findings on the second factor, including that where a work is used to critique that specific work, this factor is of little relevance. The board moves to factor 3, the amount and substantiality of the work taken. On this third factor, the request is certainly no more than a rehashing of claimant's prior argument, rejected by the board, that the, quote, heart, end quote, of the work was taken. You took my heart. You took the heart of the work. Everything I put into this is what you took. Braun IP does not dispute the board's finding that a small amount of the work was taken. Respondents took only 1 minute out of 8.5 minute video, which amounts to approximately 11 to 12% of the work, and it made up approximately 1 to 2% of the episode. You know what? Copyright board, I'm going to borrow this one. I'm going to borrow this because I'm going to use this in future cases where my 5-hour video and I take a 20-second clip. I'm going to use the percentage thing that you just laid out. So thank you for clarifying this. I very much appreciate it. However, Braun IP suggests that unless respondents could affirmatively prove that the portion taken was not the heart of the work, this is such a stupid argument. The board should take claimants' argument. Go.
She makes this argument that's absolutely nuts. She says that it's the heart of the work because that's what they decided to copy.
Oh, no. It's like the definition of a circular argument.
Yep.
Like it's the heart of the work because it's what they decided to copy. Well, why they decided to copy it? Because it was the heart of the work. Well, what is the heart of the work? I don't know what they decided to copy. Oh. This is so dumb. This is so dumb. This is why you never listen to someone simply because they say, I'm a lawyer. And if they say, I'm a federal lawyer, run. Do not walk. Run. Oh, this is so stupid. Lindsay, this is a very good point. If I use the percentage thing, I have to do the math stuff. I'm not going to do that. I'm just going to say my video big, this segment small. This is horrible. Okay. So let's go back to this asinine argument that Braun makes. However, Braun IP suggests that, oh, by the way, the reason Ian's muted, he's currently typing a legal pleading. So
I'm typing a whole bunch of stuff. So
Ian is doing work. I'm reading other people's work. However, Braun IP suggests that unless respondents could affirmatively prove that the portion was not the heart of the work, the board should take claimant's argument as fact, even if there was no evidence to support it. Well, Judge, they can't prove it wasn't the heart of the work, so I guess it was. In so doing, Braun IP cites cases not dealing with criticism and where the plaintiff actually proved what was taken was the heart of the work. They literally say you cited cases where they did the thing you said you didn't have to do. This is preposterous. I pray right now that I am somehow decent enough of a lawyer to never have a judge put this into a fucking pleading about my case. Please, God, just never let this happen to me. Please, no. This is preposterous, as is claimant seemingly suggesting that this factor must always go against the finding of fair use by arguing that the mere fact that respondent chose this portion of the work to critique is prima facie evidence that these clips were the most important moments of the work. Again, claimant only serves to undermine its credibility in making such arguments. God, if I could please make it through my career without a paragraph like that ever happening to me, I would die a very happy person. Mrs. Wilkins, catching you up. Jeanette Braun filed a bullshit copyright claim. Ian's covered it quite substantially. She lost big time to two individuals not represented by counsel. Instead of taking the L, she doubled down and filed a motion to reconsider. And instead of the judges coming back with a 3-sentence order that says reconsideration denied, the judges came back and very thoroughly, emphatically are walking through exactly how terrible the argument was in the first instance. So we're getting a little bit of a laugh. As discussed in the final determination, respondents used the work to provide context so they could properly critique it, using no more than was reasonable and limiting their use of the work to specific parts they were criticizing. Again, they cite like 5 fucking cases. Finally,
I mean, this should be so obvious to somebody who claims to be a social media lawyer. So, yeah.
Ian, she passed the bar. She is a lawyer and she is on social media. These are correct statements. She is a social media lawyer. For that matter, I passed the bar and I'm on social media. You're a social media lawyer. We're social media lawyers. I don't like being a social media lawyer. I'm fine with it. I don't really mind. As long as I never have a paragraph written like that in any opinion ever speaking about my arguments, I will be happy. Finally, oh no, it gets really bad too. Finally, the request fares no better as to factor 4. They said your other arguments were trash. This one is too. As an initial point, the request assumes that the board's finding that respondents' use was transformative and used for criticism and commentary was incorrect. It was not. And claimant certainly has not shown a clear error of law. The request seems to, in order to re-argue that claimant respondents were competitors and respondents usurped claimant's market for the work, admit that the work was an outlier from Braun IP's typical videos about copyright law in general. Oh no. Oh no. You literally said the thing. You said that this is not my usual work, which means that it has no value because it's not your usual work.
Yep. All of those estimates of 4,000 or of 7,500 are now meaningless.
Oh, it's terrible. Oh my gosh, this is awful. This is the worst SmackDown. Regardless, as stated in the final determination and as not challenged by Braun IP in the request, Braun IP presented no meaningful evidence that respondents' use of the work affected the market or value of the work. And with this admission, the licenses Braun IP presented with its written testimony go from practically meaningless to absolutely meaningless. Copyright board, stop. You've done the damage. It's dead. It's already dead. You don't need to kill it anymore. Oh my gosh. This is just, I don't know that I've ever seen this. It's like, no, we stabbed it. We're just going to burn it, torch it, nuke it, and then throw it into the ocean. Respondents took a small portion of the work to criticize its content. Full stop. Wait, hang on. I don't know that I've ever seen a judge write full stop in their opinion. I approve, in this case, as stated in... I didn't realize that the judge just keeps getting angrier as the judge keeps typing. The judge is like, I'm getting angrier and angrier and angrier because this ends up being Every sentence gets worse. As stated in the final determination, there is no rational argument here that claimant respondents were competitors, or that use of a small portion of the work to criticize Braun and her position in the Day Braun dispute would have replaced any possible market Braun had for the work, and thus, quote, thus acted, quote, as a substitute for the original, end quote. Oh my God. In sum, Braun IP, which promotes itself as a law firm knowledgeable about and experienced in intellectual
Isn't
property
that
law.
Brutal?
This is this is an unheard of SmackDown. I'm dying. This is I don't know what to say. This is not dunking. This isn't even lighting it on fire. Ian, your flamethrower couldn't do this much damage.
Oh, I would rather face the flamethrower.
Okay. All right, gotta finish. In sum, I don't know if I came with a straight face. In sum, Braun IP, which promotes itself as a law firm knowledgeable about and experienced in intellectual property law, has not presented any argument that would amount to an error of law or fact, never mind a clear one, or one material to the final determination. The request for reconsideration is denied. You know what this sentence is, this entire sentence? It is Billy Madison. It is Billy Madison at the academic decathlon, where he says, we have learned nothing within that long rambling thing that you have just offered. We are now all dumber. May God have mercy on your soul. And I award you no points. That is exactly what that was.
Oh, it's the worst possible. Yeah.
So, can I ask you where you were when you read that thing?
What's that?
I want to ask you when that came out, how fast did you read it?
Oh, I read a little bit of it, and then I was like, I want some of my reaction to be on a video. So, but it's just so brutal. So brutal.
Yes. This Lidachi, this is swearing in legalese. This is the SmackDown that no lawyer ever wants to see. And I don't know who is stinging more from this, because is it the lawyer that made the argument? Is it Janet? Is it both? Because the copyright board lumped him in as one. Oh no, yeah, there's the EDU. I just looked it up. The filing, his motion to reconsider. It was 15 pages. It was 15 pages long. His request to reconsider, 12 substantive pages. I can't believe that was real. Now, the $1 million question. Is this the end of Jeanette Braun doing Jeanette Braun things?
Oh, God, no. God, no.
Why?
I've got some other Janet stuff to cover soon.
What other stuff? There's no one can take a loss like this. This is I mean,
oh, there's more Janet. There's more coming.
But how? But how is that? How does one get up after being smacked with this opinion and then continue doing what you did before being smacked by this opinion?
Mostly it's because she's powered by being a hateful little troll.
It doesn't make sense. None of it makes sense. So, oh my. When will you learn? Joe, is this to me that I haven't learned about Janet, or when will Janet learn? I don't think Janet's ever going to learn. I don't know. I don't know if I am. She's still going after Lily? How? Lily needs to hire a lawyer so she can get attorney's fees back.
She's got a lawyer, but not on the copyright claims board stuff. She's on the defamation stuff.
Oh. Okay. Does Janet still have clients?
I believe so.
How? Just how? I don't understand that part. I don't get that. So, none of this makes any sense, except for the SmackDown that we just read. That's about it. And that was very welcoming. And yes, I'm stalling because I'm pulling up motions for Karen Reed because I do want to find the exact one I want to talk about. There's 9 million freaking motions. There's so many of these. So I might just review the printout of the docket and say what's going to get granted, what's going to get denied, and what is actually interesting. Commonwealths. Wait, what? Why are they asking for leave to allow in-court identification?
Because they want to point at her every time.
Why are they asking for leave to do that? Generally speaking, the in-court identification is kind of standard.
Because they don't always get to do the in-court identification. And
usually describe it. Are they specifying they want to be able to point at the individual? Well,
the thing is that everyone knows who this is.
Yeah, they're the defendants sitting at the defense counsel table. That's who they are.
Yeah. There is no issue as to who Karen Reed is. So.
Okay. Motion for offer of proof prior to defendant calling for a certain. Wait, Reed wants to call Morrissey?
Safe. The defense team wants to call Morrissey.
That's what I said. Reed, the defense team wants to call Morrissey?
Yeah.
Okay.
Yep.
Wow. Comments motion will be requesting use of chalks and directing both parties to provide visual representation chalks prior to using. Okay, so we want to see the outlines. We want to do the stuff. Show me what you're going to present. They want the Cellbrite demonstration. Generally speaking, you're going to be allowed to do a demonstrative. Especially experts are usually allowed wide latitude in doing demonstratives. As long as it's consistent with their testimony. Admit results of a blood draw. Preclude reference to an alleged bad character or any prior misconduct of the victim or any witness. Oh, I want to read that one real quick. Let me see. Save that. Preclude defendant from raising third-party culprit defense. Oh, so they're trying to make another ruling on this one. They're not. Well, you know what? I'm not going to put anything past Canoni. I'm not going to at this point. False and irrelevant statements by Proctor. Got to talk about that one briefly. Because you know what? Why not? Emotionally allow counsel to take grounds for objections. Oh yeah, Jackson. I like this one. It's not gonna get granted, but I like it. I'm gonna pull that one out first, I think.
I think the Commonwealth consents to it, and I'll tell you why in a bit. Or in a moment here.
Because they want to. Because they want to.
Oh, I'll tell you why. My food is just arriving. I'll tell you.
Go get it. Yep. me see. Let me pull them down real quick while we pull these up. Oh, nope, that's too big. I don't like that. Big screen. There we go. Smaller. Council has motion pound. Motion reconsideration court. There we go. I wanted the Crosby. Crosby we're going to do briefly, not too long. A lot of these aren't really meriting a whole lot of discussion because they're not the most comprehensive thing in the world. Commonwealth's witness list. Affidavit of Lessie. I don't need the affidavit. Let's see. We'll take a look at the witness list briefly, see if there's anything surprising on there. And then why not talk about the statement released by Michael Proctor and the family, which likely he's an agent of the state. He's an agent of the Commonwealth. He's an actual officer who is subject to these sequestration orders and gag orders. You don't get to just fucking bypass that. I guess we can briefly mention that there was the writ of mandamus that they had filed in federal court. So Karen Reed. So let's flip, because I'm now 43 motions filed this week alone. 43 motions. Terry, the 3D printer is not running. The sound you were hearing was Ian typing things because Ian was doing work in the back, which I don't mind at all. So no, the 3D printer is not running right now. Just we'll mention it briefly, but after I swoop, let's do this. Swoop, talk about Karen. Okay, Karen Reed has trial coming up, and it's right around the corner, going to be in first week of April. And we are therefore getting a ton of these pretrial motions that are relatively standard. Some standard, some not standard. Okay, motions in limine are motions asking the court to make a ruling on evidence before the evidence is presented to the court. People misconstrue this motions in limine being motions to limit, but it's not really just motions to limit. It's motion for the judge to make a pretrial determination on evidence so that we know what we can say, not say, use, not use, so that we're getting out ahead of these things that we need to get ahead of. We do these all the time. For example, I had a therapist in a case that wanted to testify to certain things. I said they weren't qualified, so I filed a motion in limine to have them restricted as to what they could say going into the trial. Relatively standard. You can also file a motion in limine if you think you're going to face an objection on an issue and you want to get ahead of that objection. So again, relatively standard. Other things that happened in the Karen Reed's case was Karen Reed had filed a writ of mandamus to the federal court, asking the federal court to basically set aside the trial that is existing now, basically mandate to the state court, you cannot proceed with this trial because Karen Reed herself was and should have been acquitted of a charge because the jury was not allowed to come back with a lesser charge or come back and acquit one and not the other. My prediction when that thing was filed was that it had really nowhere to go. You had to file it because you have to make the argument, but it likelihood of being granted, no. I also written of mandamus.
Oh yeah.
That was never going to go. Just like the motion to dismiss or set aside back after the fact. In no circumstances is a judge going to go back and ring that bell. Ain't going to happen. So the habeas petition, not writ of mandamus, the habeas petition. Sorry, the holding of the body, habeas. Either way, mandamus, habeas, same concept. It was never going to win. Contrary to what a lot of people said about it, but whether it should win, what should be heard or what shouldn't be heard, it just wasn't. However, they're going to appeal it because they have to. You have to keep all of these issues in the fire and keep arguing them because you have to preserve that argument. People are saying my sound is weird. Let me see if I can't tweak this a little bit. There, we'll see if that does anything better. Anyways. Not sure why the mic was acting up, but the habeas petition, I don't see that being as a really successful avenue, but you have to pursue it because you're defense counsel. You have to. Did you really get fried chicken? Yes, you did. In solidarity with your client? Yes, you're nodding your head. Yeah, I see you. So, Matt Damon compels you. Yes, mandamus. Matt Damon compels you. That's really not the curious part, but as a part of some of these motions in the Karen Reed case, you have a couple determinations that the judge needs to make. So let's take up a couple of these.
I was also going to tell you why I think they might agree to the Trooper Proctor thing.
Oh, yeah. Tell me why the Trooper Proctor thing.
Trooper Proctor's allegation against Yannetti was that Yannetti went to the school to, harass, Proctor's sister.
Yep.
Which turns out to be not true. So if I'm the Commonwealth, I'm like, yes, let's preclude any mention of that. Because precluding any mention of it, it prevents them from bringing up the lie too.
True. That's true. So. We shall see. So let's see. Let's start with our witness list because we got a witness list. Nope. Apparently my computer doesn't want me to do that. All right, don't freeze. All right, so Commonwealth has their list of witnesses. Nothing surprising. Brian Albert. Kirsten. So the Alberts are all listed. Record keeper. Sure. Caves, Higgins, juveniles. These are all the same people. Aiden Kearney is listed. So Turtle Boy's listed.
Yeah, they're going to try to keep Turtle Boy from
being present in the courtroom. I saw some interesting takes on this. I don't have a dog in that fight. I don't really care who's in the courtroom. I don't like people mean mugging the jury. That kind of bothers me a little bit. But certain people are going to be allowed to be in the courtroom. We'll see. If I don't know what Canoni's going to do, but if I'm Canoni, I'm like, what's good for the goose is good for the gander. If you want these witnesses to stay in the courtroom, if the Commonwealth wants certain witnesses to stay in the courtroom, the defense gets to have certain witnesses to stay in the courtroom. But I think that I have always been of the mind that the rule on witnesses and the rule excluding witnesses, sequestration orders, should be pretty tightly followed, and that I don't like witnesses being allowed to be in the courtroom during testimony of other witnesses, period. Even if we think we know, they know what's going to be said.
I don't like doing it to journalists.
No, that's true. And Turtle Boy, from what I've seen, the only relevance that he has, and that's going to come down to whether or not the Commonwealth's going to be allowed to go anywhere near their allegations of witness intimidation. I've never really cared for that allegation because I don't see a whole lot to it, and I don't see how it's relevant in the trial of whether or not Karen Reed is guilty. I've always viewed that as being nothing or instituted for no purpose other than to prejudice the jury. The
other thing is, if I was the judge, I wouldn't say anything, but I would quietly just be sitting there taking note. And if they go through the entire trial and don't call Turtle Boy, I would ask them to stand up and explain how it wasn't a First Amendment violation of Turtle Boy.
I mean, he would
I'd be telling them that there'd be a dollar amount attached to it. If
I mean, he would basically have a claim. He would have a claim for improperly including him on that witness list, because you're supposed to list all the witnesses you intend to call in your direct or could call in your direct. Rebuttal witnesses don't have to be listed on this. If you intend to call someone in rebuttal, you don't really have to list them here because you don't know what you need in rebuttal until their case in chief is put on. And this is one of the questions I have too, M169, is I don't like the claim that the Commonwealth has on this one. I think it's bullshit. I really think it's stupid. And I thought that Lolly got away with a whole lot at the first trial in making reference to this, of even the suggestion. And Canoni tried to keep it out, a little bit of it, but some of it came in through, who was it? Which witness? Jen McCabe? No. Who got to open that door? Who opened that door? Was it McCabe?
I think it was Jen McCabe. Yeah, I can't remember.
Who got out of her mouth before an objection could be heard?
Ally
Got
McCabe.
Out of her mouth about how their family had been intimidated or something like that, and that was, that was that little crack of the door, and the defense. Here's the thing. I don't know. I think from the defense tactically, I wonder if they are debating whether or not they want to drive a truck through that again to the extent it gets opened. I think they want to keep that closed. I want to keep that closed. If I'm defense counsel, I don't want them going anywhere near this. And 100%. For that matter, I would say that Kearney and anyone associated with those allegations are 100% rebuttal and are not properly included on this witness list. So I don't know whether that's going to hold a lot of water. I don't think Cannoni has the biggest.
I mean, if I'm Carney right now, I'm bringing my lawyer and I'm asking to get on the exclusion list from the sequestration order.
Yeah, because I'm reporting and documenting, and there's nothing that can say. I mean, he's been documenting and reporting on all this stuff. Yes, he's very involved, and he has a very strong position on what the outcome of the case should be. I get that part. You're allowed to have those positions and also be reporting from inside the courtroom and be a journalist that's doing those things. And it's kind of a shitty move. So we'll see. We'll see how this plays out. I don't know. Here's the challenge, though. There were some suggestions that if Kearney's on the list and on the witness list, and if Judge Cannoni imposes a sequestration order or a rule on witnesses and it applies, and Judge Cannoni says it applies to all the witnesses, that some people could simply disregard that. That is not how that works.
They'll throw people in jail.
Absolutely, unequivocally throw people in jail. The fact that that happened in the last trial is pretty astounding to me, and I guarantee you that if that is done in this trial, at least on the, here's the thing, Commonwealth and police witnesses tend to get away with a lot more than defense witnesses do in trials, just as a matter of speaking. But I can guarantee you someone's going to find themselves behind bars if they just say, you know, Judge Cannoni, your order isn't worth anything, and they just decide that they're going to go ahead and report from outside the courtroom. Because here's the thing. The sequestration order is issued by the judge to all witnesses. It is an order of the court, and if you violate that order of the court, you, while not a party to the case itself, are in direct violation of a court order and a court directive, which means you're in direct contempt. Direct contempt is immediately punishable by the judge that holds you in contempt. For those of you who ever watched the trial that we followed in Atlanta, Fulton County, the Young Thug trial, we talked about direct contempt and how someone can be held in direct contempt. We've gone through all that. So you violate the direction of a court when it comes to rule on witnesses at your own peril. And it ain't going to be, it's not going to turn out very well for you. So I would very much caution against playing chicken with a train, especially when that train is a judge's order that says don't talk about the case. And that goes to the McCabe's, the Alberts, everybody involved. I wish. What?
They'll throw you in a cell.
Oh, yeah.
Like, yep.
Oh, yeah. Absolutely. Okay. So this one was a big nothing burger. People were talking about it. It's really nothing. Redact the manner and death concerned in the death certificate. It's going to get denied. I think that there's no way of hiding this from the jury. I can understand in some cases.
Did you read the case law that they cite?
I did, but there is nothing that is. Here's what's kind of stupid. Even the case law they cite, right? So the Commonwealth is saying, do not reference the fact that the death certificate says undetermined.
Right.
That's what the Commonwealth is saying. We cannot reference that the death certificate says undetermined. Here's the problem with that. The defense absolutely and unequivocally in cross-examination gets to bring up that on that death certificate it said undetermined. So the Commonwealth is saying that we're going to redact it, but in testimony, that is absolutely coming out. you absolutely have the right to impeach. And you saw it in the first trial. You get to bring it up. I don't care how much you fight against bringing it up. You get to bring up that death certificate said undetermined as impeachment. So this one, denied. Well, it should be denied. Even if it's granted, it's coming up in cross. In court identification. Let me see this briefly. Ruled that where eyewitnesses do not participate before trial in an identification procedure, good reason for in-court identification must first be shown. Okay. What's the good reason they're citing to? What's the good reason for pointing at the person?
They're saying it's not, not everybody knew exactly. So, I mean, there's no question as to
Come on.
who they're referring to when they say Karen Reed.
That's stupid. This is just... That's mostly harmless fuzzball. That's why I'm saying this motion should be denied. But let's say it gets redacted. The defense gets to bring it up. They get to bring it up because it impeaches the credibility of the individual that's testifying. You can bring up, you can present the evidence in a piecemeal fashion. You're allowed to bring it in a piecemeal fashion, but don't think that the defense is not going to be entitled to drive a fucking truck through it. And that's what the defense did last time. They're going to do it this time. So even if it gets redacted, because you don't want any prejudicial effect being given to the jury because it says homicide or suicide. Homicide being, usually you see these motions when the manner of death says homicide because it's suggestive to the jury that it was a wrongful homicide when that is not necessarily the case. Homicide simply means death inflicted by another. Okay, could be lawful, could be justified, could be any number of circumstances. Accidental infliction by another person, but it was just inflicted by another. But you don't want that showing on the death certificate because it is reading the word homicide is persuasive on a jury as to the manner of death because juries don't understand that homicide might be completely lawful. So I get it under those circumstances. But in this case where it's undetermined, don't think the defense doesn't get to bring up that it was undetermined. So that's coming in, whether it's redacted or not. That's why I said, just why are we even considering that motion? Why not just...
Did they bar that at the first trial, though?
That's what I was saying. They barred it. No, they barred it. They redacted it at the first trial, but the defense got to drive a truck through and say it was undetermined in cross-examination. That's what I was saying. Death certificate comes in, perhaps redacted. I don't like the fact that it's redacted. I mean, just let it in. But, yeah. In this one about pointing at the defendant, it's going to get granted. I mean, it's going to get granted just because you get to...
It's Bev, but there's no reason to allow it.
I don't see a reason to allow it, but again, I don't see a super compelling reason not to allow the identification. Not one that I think that's going to be heard by any appellate judge. Preclude defendant from raising third-party culprit. All right, so here's the thing. We talked a little about third-party culprit defense. We were talking about Leo. So, judge, please say don't use third-party culprit. Here's the problem. That entire first trial cuts against this. And yes, this is a new trial. But let me tell you what an appellate court is going to do if Judge Bev comes in and says, you ran a whole trial on third-party culprit, and we're going to say you can't do it this time. I cannot think of a faster ass-kicking by the Court of Appeals that would happen.
The other thing is that the thing about the defense claim has been nebulous from its origin is fucking irrelevant.
Doesn't matter.
Because the defense doesn't have to get it right from the beginning, right? So, yeah.
Yeah. So.
The defense can have theories and they can come around to it later.
Does this motion feel like it's more for the media than anything else? No, they think they're going to win.
No, I mean, I think they might win on that.
Third-party culpability? On denying it?
It's Bev.
That would be quite the fucking ruling.
Mm-hmm.
That would be quite the ruling. Now, I have been I don't know. I have not liked as much stock as the defense puts in the third party culpability case, but I also see why they do, because juries need answers, or juries want answers. And if you say, nah, bro, not beyond a reasonable doubt, a lot of jurors will simply say, oh, you're just trying to hide behind that standard, which, bothers me that we have that discussion, that like hide behind that standard. It's not hiding behind shit. It's that the burden wasn't met. I believe that burden beyond a reasonable doubt actually is beyond a reasonable doubt. I think a lot of people misconstrue what that actually fucking means. And they end up saying, well, there's no other thing that I can really see being plausible. So they're guilty. I'm like, no, that's not the thing. Nope. That's not how that works. No. So I get that juries need an answer and you want to be able to give them one. But I've never thought that was the strongest argument. I've always thought the strongest argument was that I just have to look at Trooper Paul and say, no, I disagree. This individual was not pirouetted through the air by a vehicle going 25 miles an hour in reverse down a curve, hitting an individual. I don't believe the science and what they had projected or put forth as science. It never made sense to me. I don't need a third party, but that's me. I'm not a juror. So.
I mean, that's the thing is that they should still get to argue it.
Yeah.
So, yeah.
They have put forth enough, both in circumstantial and in motive, opportunity, all the above. Third party culpability requires a bit more than just mere speculation, right? Where's the case law he cites? Because he's probably got the standard here. There we go. The Massachusetts Guide to Evidence provides that evidence that a third party committed the crimes charged against the defendant or had the motive, intent, and opportunity to commit the crimes is admissible, provided that the evidence has substantial probative value. In making this determination, the court must make a preliminary finding that the evidence is relevant, is not too remote or speculative, and will not tend to prejudice or confuse the jury. If the evidence is otherwise admissible, the court must also find that there are substantial connecting links between the crime charged and third party, or between the crime charged and another crime that could not have been committed by the defendant. There's enough. The defense has enough to clear this threshold. In my opinion, they do. Both in the cell phone data. They've got the cell phone data as far as the health data, the tracking of the steps and how those steps transpired. They have it in the text message communications. They have it in now I'm not really a fan of a lack of evidence as evidence, but they do have it in the communications between the Alberts and McCabe's.
Sometimes the lack of evidence can be highly relevant, right?
It can be, especially when there's notice back and forth about a phone being sought, and then all of a sudden the phone is dumpstered.
Well, that's not a lack of evidence. That's
evidence. That's evidence.
That's a fact, right?
Yeah, that's a fact. That's there. What else is there? There's the conflicting evidence of someone going inside the house. That's one.
Yep.
There's the inconsistent statements about return times for different people at the home. That's another circumstance.
And the thing is that the evidence can be disputed on these things. You have to take the evidence for the proposition at its best. Yeah. So, even if it's a situation where it's like, okay, some extremely sketchy dude says that they saw somebody else, do it. It's like, well, that's some evidence. That's jury could believe the extremely sketchy dude.
You have investigation being conducted after conflicting out. I mean, you've got enough. Like the hurdle there is. Let me be clear on third party culpability. There is a hurdle you have to clear. It's there. It's a hurdle. But when you deny the defense the opportunity to present a defense, an affirmative defense, you are making a big ruling a big ruling.
And it's one you've got to get right because
the appellate court looks at that and said, it's not a clear error. I mean, it's basically they're looking at that determination of whether there was enough. And if the Court of Appeals finds that there was an iota that would have allowed this defense to go forward, then you're back doing the fucking thing again. So you would rather, I mean, we've already done this trial going on 2 times.
It's not one of those things where you can say that this is an innocent error where it would have been different had things been otherwise.
Mm-hmm.
So, yeah.
So, like I said, anything is possible. I think that if the judge puts her eggs in this basket, holy crap. I mean, if you're the defense, do you seek interlocutory on this? I think I do.
I don't know that there's time.
I would seek a stay, and interlocutory stay gets denied, but then you immediately appeal the stay. I don't know. Would this denial be grounds for interlocutory appeal? You deny the defense, an affirmative defense? I think it might be. It's kind of like ruling on it might be. So I don't know. That's a whole lot to put in one basket. Okay. Motion limited to preclude reference to any alleged bad character and prior misconduct of the victim or any witnesses. So the Commonwealth is asking. Now, here's the thing. I love that they're hiding behind this. So the Commonwealth is saying this. They're focusing. Don't focus on the bad character misconduct of the victim. Let's be honest. They want you to not do any witness. That's what they're focused on, not the victim. I know they're saying that in their motion.
They also want to bring up the Aruba shit.
Yeah, the Commonwealth wants to bring up all the dirt from the past, but they don't want you to bring up any bullshit about the other person. But the whole don't bring up any bad character or misconduct of the witness. Why not? If the misconduct is relevant, specifically if it's Trooper fucking Proctor, whose misconduct was Legion.
That's insane to me that they're trying to leave out his his stuff.
Mm-hmm. All right, so what are they trying to... This is kind of wild to me. Moves this court to order counsel to refrain from making any reference before the jury of an alleged bad character or alleged misconduct of the victim or any witness without prior court permission. Specifically, well, here's the problem with this. Prior misconduct of the or alleged bad character, alleged misconduct of the victim or witness. There are certain things that I am allowed to say about a witness no matter fucking what. They're a liar. Example, I'm allowed to say that. They have lied in the past. I'm allowed to say that. They have a criminal conviction for lying. I'm allowed to say that. They were terminated for cause for lying, or I'm allowed to say certain things. You can't restrict me from saying those things. Now you're seeking a ruling beforehand on what I'm allowed to go into. I just don't think this dog's going to hunt. I don't know. The defense has made allegations about civilian witnesses and law enforcement witnesses, and the public has been saturated with unfounded claims of bad acts by Commonwealth witnesses. Well, here's the thing. When you say unfounded claims, you're going to have to be a little more specific, because I will give you the benefit of the doubt that some of those have been speculation. I will also say that some of them, Trooper Proctor searching, making the claim about the no nudes, some of those are pretty fucking well-founded. So let's go ahead and be specific with our words. At the previous trial, the defense lodged a slew of claims of alleged bad active witnesses. Indeed, the defense is engaged in a comprehensive campaign to inundate the public with its claims and has repeatedly declared or implied that the Commonwealth, the prosecutors, the court, the trial court employees, and witnesses are corrupt, declaring that virtually every civilian witness, police officer, and first responder was complicit in a cover-up of evidence, and implying that nearly every witness is a liar. I don't think they said every witness. I didn't think they said that.
Most of them.
It was just all the ones that kind of had
oddly... Just all the ones that kind of seemed like liars.
all the ones that kind of had very close connections both before, during, and after this incident. Like
all the ones that like butt dialed for like 45 minutes.
Oh no, the butt answered and hung up. Butt answered and hung up during an act of lovemaking that should not be physically possible. So
I mean, I'm just
or Higgins leaving out a phone call that he is now seen on video making. There is some shit that I can bring up because it makes your credibility, let's say, questionable, to say lightly. So, yeah. Plus, I don't think that they were really saying a whole lot about the first responders, the ones that were first there. I think the defense did a pretty good job of saying that they weren't in the same car when certain statements were made, or that some of this might have been overheard. People just misremember shit. So, and again, I don't know that. But going after the individuals that were all out drinking that night, I'm sorry, that's fair fucking game. If you guys were all out at a bar drinking, every one of you were. And I love, here's the one fact that I think that's very interesting to me. The Commonwealth loves to cast aspersions to Karen Reed drinking all the alcohol she drank. How the fuck did everyone else get home to 34 Fairview?
Oh, they drove. Drunk?
Did they Uber? Did they take a cab? No, they all drove home. And they were all drunk. Let's be honest. They all were drunk. They all did stupid shit. I'm allowed to call out stupid shit for the people that are there. I'm allowed to bring up that you drove home drunk. I'm allowed to do that. I'm not making not inundating the public with my claims. I'm saying that your memory is shit because you were fucking hammered and you drove home. And your text messages don't line up with what you're telling me happened. That's what I'm saying. I'm allowed to do that. Such allegations have no foundation or bearing on any issue in the trial. Yes, it does. If you don't remember something, or if you lied to me about something else, I get to fucking bring that up. Whether during opening statement, during cross-examination of Commonwealth witness. Oh, during cross? Oh, baby. No, this is fair game, baby. During direct examination, defendants, witnesses. Maybe not during direct.
I mean, all of this
right?
is just asking for the defense to have to, to run the trial with one hand tied behind their back.
Two hands. 2 hands and both feet. Judge may properly exclude evidence or introduce merely to show the bad character of a witness. I'm going to need a citation here, counsel. Further evidence of prior misconduct may not be used to impeach a witness's credibility except by production of records of criminal convictions pursuant to limitation requirements. Trial judge has sound discretion. You are missing out a whole lot of case law here, because if you're telling me the only thing I can do is bring up prior convictions to a witness that's on the stand, you haven't been practicing law for very long. Here's this phrase I haven't heard before. A judge's determination will be upheld absent palpable error.
He's basically telling the court, you can go ahead and be wrong and you won't get overturned.
Kind of. Yeah, just a bit.
I mean, that to me suggests that he knows the judge is kind of leaning.
Oh, he does. He absolutely does.
And so he's like, Judge, you can make a mistake and nobody will care because the standard of review is so high that nobody can. Yeah.
I had my associate was writing. What was he doing? Hang on. Let me pull this over a second. So my associate was writing, and this is going to be relevant. My associate was writing a closing argument, so written closing argument on a equitable distribution trial for a divorce case, and came to me because I'd given him a case that had just gotten published by the Court of Appeals, and he read it, and I said, "Here, read this," because it's actually, I get these things sent to me as they're being published, and I read them because I think it's important to know what's happening constantly. So I give it to my associate, and my associate comes back into my office and he says, I kind of want to use this case in my closing argument or in the closing argument. I said, great. How are you going to use it? And he gives it back to me. And he points to the page, and I start reading it. And he says, "This is like the determination of whether this constitutes a gift or a loan is a question of law and is reviewed de novo." And I was like, "Oh shit!" That's the Court of Appeals saying I get to glance at those facts and see if you got it right in the first place. Which, if I'm an appellate lawyer, I love that. It's my favorite thing in the world, because now I get to say judge got it wrong in the first instance, and I get to argue the evidence all over again. When a trial court reads that the appellate court reviews their decision de novo, the trial court's going, I might as well get this. I should probably get this right. And my young associate is looking at me and saying, do I mention this in my closing argument? And if I do, does it sound like a threat to the judge I'm going to appeal? And I was like, here's the thing, young Padawan. We are going to teach you how to make a threat without making a threat. You give the judge the very clear indication that a decision is his to make, and that it is his to make, and it's his to make on the facts as presented, and that a court, in reviewing this on de novo review, like you subtly slide it in there, because no trial judge reads de novo and doesn't think about it going, I should probably get this one right. So you slide it in there so that they know that they have permission, or that they are under heightened scrutiny, so to speak. Conversely, when you say judge, the appellate courts basically say you can make the absolute terrible decision, and unless it was so terrible that I could taste it, it's going to get upheld.
Yeah.
That's the argument being made. Now, I will say I appreciate criminal law, because criminal law motions are 3 pages versus like civil motions, which are like 10. So I like that we make the motions quick. I said that out loud, and I'm probably going to regret that, because there's probably a motion here that's a lot longer. What was this one? Who is Christina Hanley? So defendant is asking to allow a demonstrative or chalk to the jury.
She's the glass expert.
Oh.
And basically all this is her evidence was super confusing, so we want to show a diagram to show why her evidence.
This is the shattered glass, the one that they like didn't recover glass from.
Yeah, this is the, reassembling glass and all of that stuff. So yeah.
But correct me if I'm wrong. There's a whole lot more taillight reassembly than there was glass, like from the actual glass that he was alleged to be holding, right?
Yeah. Yeah.
Like a lot more. It was a big difference.
Yeah.
Okay. All right. So we want to actually be able to chalk out how we do this stuff. That'll be a fun demonstrative if that's allowed. I'll be very interested to watch that. Huh. I think that's helpful. I am a fan of demonstratives. I understand why courts don't allow them, because they can be a little prejudicial when they're not completely accurate, but I like them. For example, here's a demonstrative I would have loved. Trooper Paul. Can we do a demonstrative of what the torso of John O'Keefe was doing based on your testimony?
Paul, can we do a demonstrative of the inside of your skull?
Don't do that. but his testimony, I really wish there could have been a demonstrative there to show exactly how far we are talking this vehicle through John O'Keefe in the air, and how the body moved. Like if I could see a 3D rendering of Trooper Paul's testimony, and to see this body pirouetting in the air, going 25 feet, something like that. Just show that to the jury and say, hey, jury, that video, put that in your head, and then imagine that actually happening. And if it can, and then I want you to do that. Trooper Paul, in this case, is the first time when I looked at witness in this case, and I was like, holy shit, this did not happen that way. Like there's no way that what you just said is true. So now I'm not saying that Karen Reed didn't hit him. I'm not saying that. Actually, I don't have to say that. The ARCA witnesses said that. But, and I don't think Trooper Paul just didn't convince me that it happened. And here's the problem. The burden in this regard to prove beyond any reasonable doubt is the prosecution. And when I, after listening to your main witness testifying as to how this thing was to transpire, I'm going, that doesn't make sense. You have not met your burden. That's where my head's been on this case for a while. Commonwealth's motion for offer of proof prior to defendant calling or summoning the Norfolk District Attorney and victim witness advocate as witnesses and request for order that neither is subject to a sequestration order. You can't sequester the DA. That's kind of just...
They should sequester the DA.
You wish you could. I wish you could. I can't see a world in which any judge is going to say, DA, you are sequestered. Unless that DA is the direct defendant in a prosecution. I don't know. But what are we doing here? Why are these motions 9 million words long in the title? Now comes the Commonwealth moves its court to order defendant make a satisfactory offer of proof prior to calling and or summoning the DA. On March 6, 2025, defendant listed both the DA and the victim witness advocate as potential defense witnesses. When a defendant resorts to the extraordinary means of calling prosecutors a witness, he must make a set. Well, if you're going to take it out of quotes, why don't you say she? Make satisfactory offer of proof. Offer of proof is to the need for testimony of the prosecutor. Offer of proof basically saying, why are you calling them? Prosecutor should be called only where there is a showing the prosecutor's testimony is relevant material and not cumulative. All right, so what do they want to elicit from Morrissey? What do they want to get out of him? That's my question. My question is, what are they going to put him on the stand for? Please speculate. You're laughing in a way that tells me, why are they putting Morrissey on the stand?
I think they want to go with the whole theory of the conspiracy, including the
Morrissey,
including the Commonwealth.
Wow. Okay. All right. Canodia's going to require an offer of proof. I can tell you that right now.
Yeah.
And I think that the likelihood of Morrissey staying on this witness list is pretty slim. Yeah, I cannot see them calling the elected DA. I can't. How is it relevant to the determination of whether there's guilt or innocence? Now, here's the thing. If we get into the opening the door of whether there was intimidation or this other stuff, if that door gets opened, then maybe my opinion on Morrissey changes. But what's the hostage video? The hostage video. What's the hostage video? If one of the mods has a link to that video, I haven't seen that video. You're going to try to change my opinion, chat, on whether this comes in or not? Yo, I've been reading the pleadings, and I've been in court practicing law. I've been waiting for this trial.
Have you not seen the hostage video?
No. I have not.
It's Morrissey doing a video where he's saying, "These are good witnesses. You've got to stop." Like, and it makes it look like there's somebody just off frame with a rifle pointed at his head.
Hang on. Okay, I think I remember. I remember allusions to this. Were people making a comment about it? Hang on. I gotta pause here real quick because I gotta find the stupid thing. Michael Morrissey.
It's in the private chat, I think.
All right, hang on. We are going to. Oh, this is gonna be bad. This is gonna be bad right at the beginning. I'm not gonna like this, am I? Let me tell you, I'm not gonna like this because he begins the video by saying, "This is gonna be the first statement of its kind." All right, sorry, folks. I've hijacked this to actually understand what the hell we're talking about. Here we go. Is it really 5 minutes?
It's 5 minutes, but it's a worthwhile 5 minutes because you get to see Peter Pettigrew here.
What's the date of this? What is the date of this video? Hang on, let me look this up. Like I said, I've never seen this. This was dated, originally published August 23rd, 2023.
This will be the first statement of its kind in my dozen years as Norfolk District Attorney. The harassment of witnesses.
I think it's funny that it says Norfolk. I know it's Norfolk. I know it's Norfolk. I know that, but it definitely sounds like fuck to me. So
And the murder prosecution of Karen Reed is absolutely baseless. It should be an outrage to any decent person, and it needs to stop.
Wait, hold the fuck up. Is he talking about the credibility of witnesses before a trial?
Yes.
Huh. Well, that's interesting. And prejudicial as fuck. Okay.
Innuendo is not evidence. False narratives are not evidence. However, what evidence does show is that John O'Keefe never entered the home at 34 Fairview Road in Canton the night he died. Location data from his phone, recovered from the lawn beneath his body when he was transported to the hospital, shows that his phone did not enter that home. 11 people have given statements that they did not.
Wait. Whoa. This was August of 2023. When was the first trial? Karen Reed. And when was Yanetti's first? When was Karen Reed's first public statement? When was the first time that the defense came out and openly made the statement they did? First trial, April 16, 2024. Hang on. Professional conduct. When was the first? Rule 3.8. Prosecutors are subject to special rules. Defense, not same rule. Different rules. Different jobs, different rules. All different rules. There's a specific rule on point. Blah, blah, blah. Don't prosecute. Don't do these things. There. Right here. F. every state has a rule almost directly on point for prosecutors, specifically prosecutors, except for statements that are necessary to inform the public of the nature and extent of the prosecutor's action and that serve a legitimate law enforcement purpose. You shall refrain from making extrajudicial comments that have a substantial likelihood of heightening public condemnation of the accused, and for making an extrajudicial statement that the prosecutor would be prohibited from making under Rule 3.6 of this rule, or this rule. And then you have to do it even further. Take added steps to prevent investigators, law enforcement, employees, or other persons assisting or associated with the prosecution from making those statements. Where's the other part of that rule? Hang on. Where's 3.6? Give me 3.6. Hang on. Table of contents. Rule 3.8. I want to go back. Show me 3.6. If I go up here, can I do it? Ah, I can. No, I said 6. Oh, this is so annoying. Rules of professional conduct. How have I not seen this video? Rule 3.6. If you're participating in the investigation or litigation of a matter, shall not make extrajudicial statement the lawyer knows reasonably know would be disseminated by means of public communication will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. You're allowed to state, here's what you're allowed to say, the claim, offense, or defense involved, and the identity of the person involved, the information contained in the public record, that an investigation is in progress, the scheduling or result of any step in litigation, request for assistance in obtaining evidence. So, Koberger, statement saying, hey, anyone that's out there that has info, give it to me. A warning or concerning or danger concerning the behavior of the person involved. So, look, this person might cause a harm to the public. You can see the identity, apprehension, fact, time, circumstance of arrest, and the identity of investigator arresting officers. This is he trying to do this under E? This rule does not preclude a lawyer from applying to charges of misconduct publicly made against him or her from participating in the proceedings. No, that's not that rule. No, that's not that exception. Notwithstanding the paragraph, a lawyer makes a statement of a reasonable lawyer would believe is required to protect a client from substantial undue prejudicial effect. No, these are witnesses, not your client. No. You file motions. You don't make statements. What is happening? Why is this happening? What?
Did not see John O'Keefe enter the home at 34 Fairview that night. 0 people have said that they saw him enter the home. 0. No one. Some have, without any evidence, pointed to 18-year-old Colin Albert, a nephew of the homeowner, and accused him of attacking John O'Keefe as he entered the home. But phone evidence shows O'Keefe never entered the home at all.
What? Why are you doing this? This is not included in the list of those things. This is not include. I don't care if what he's saying is true or not. I don't give a shit if what he's saying is true or not. This ain't in those things that you're allowed to talk about.
Testimony from witnesses tell us that 18-year-old Colin Albert had left his uncle's home before John O'Keefe and Karen Reed had arrived outside the residence. There was no fight inside that home. John O'Keefe did not enter the home. Colin Albert, the young man being vilified, was not present when Reed's vehicle and John O'Keefe arrived on the street. This is a false narrative. Colin Albert didn't commit murder. Jennifer McCabe.
Are you fucking kidding me? You are allowed to say certain things and only those things. You are not allowed to try your case publicly in the media as the prosecutor. What the fuck is this? What is this? I don't care if there is truth or lies. I don't care what. If everything, let me tip it this way. If everything he is saying is true, he is still not allowed to say these things. Even if everything in this statement is 100% true, you cannot say this in a public statement.
Matthew McCabe, and Brian Albert. These people were not part of a conspiracy and certainly did not commit murder or any crime that night. They have been forthcoming with authority, providing statements, and have not engaged in any cover-up. They are not suspects in any crime. They are merely witnesses in the case.
Oh, now I see why you guys call it the hostage. I get it. Okay. I see the joke there. Okay. I see that part. Still not allowed to say it. I don't care if it's true or not. You can't say these things. You can't say these things, even if they're 100% true. You can't say it. It's not allowed.
To have them accused of murder is outrageous. To have them harassed and intimidated based on false narratives and accusations is wrong. They are witnesses doing what our justice system asks of them. The autopsy of John O'Keefe was conducted by a forensic pathologist from the office.
Nope. 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 Mm-mm. Nope. Mm-mm. Mm-mm. Nope. We're talking about the autopsy. We're talking about the pathologist. We're talking about. Mm-mm. Yeah. Huh. Mm. Here's the big distinction, Ashley. I love this. The Koberger 911 call was gotten by our local news. It was. The Koberger information was disseminated publicly. You are allowed to make certain things public. You're allowed to release results from your report and your investigation. This is different than releasing information and documents. This is making a public statement. This is argument. This is you arguing not just that your case is righteous, but that the defense case is not. This is you arguing your case to the media. Very different. Even the Koberger statements, which, mind you, the Koberger statements by the prosecutor, I had some issue with those, and I think the judge did. Judge at the very beginning didn't particularly care for them either. Thus, the fucking gag order. Even those came pretty dangerously close to violating the rules on what a prosecutor can say, and that is nowhere fucking near what this is. The prosecutor in Koberger basically read the indictment or read the probable cause affidavit. That's public record. That's what you're allowed to say. You're allowed to say the PC affidavit. But to opine on credibility of witnesses and offer narratives not in the public record, that is not allowed. It's not allowed. That's not allowed. And we're 2 minutes in.
The office of the chief. The doctor found that the injuries that left John helpless in the cold were not a result of a fight. She further found that the line of abrasions on his arm was consistent with blunt trauma, not an animal attack.
See, here's the thing. Maybe you can say the first one if it's in your PC affidavit or it's in your indictment, because I imagine part of that probably is. The doctor found that this was consistent with being struck by a vehicle. Cool. You can say that. The second part was not in your affidavit, not a part of public filing. Don't get to say that part.
A grand jury of everyday citizens heard the documented evidence and testimony before making a decision.
No. The
subject of that murder indictment.
Nope. Hang on. He's talking about grand jury? Wait a second. He's talking about the evidence presented to the grand jury. These are sealed proceedings. Has the grand jury proceeding been unsealed? Do we have the grand jury? We talked about this in Koberger, about the defense seeking to unseal the grand jury indictment proceeding and the grand jury investigation. This is the Norfolk DA, right? Is Norfolk a large county? Why are you freezing? You're freezing at the wrong time. I need to see the rest of this video. I need you to not freeze.
The subject of that murder indictment enjoys the constitutional presumption of innocence. Why should the witnesses who have committed no crime be afforded less by members of the community? They should not be harassed for telling the government what they heard or saw. I'm asking the Canton community and everyone who feels invested in this case to hear all the actual evidence at trial before assigning guilt to people who have done nothing wrong. And certainly before taking it upon yourself to harass citizens who evidence shows have done nothing in this matter but come forward and bear witness. We try people in the court and not on the internet for a reason.
Sir, may I draw your attention to what you're doing right there? Wait a second. You can't seriously be reading a statement. You can't seriously be reading a statement on the internet in public.
The irony is palpable.
Opining as to the innocence or guilt of both witnesses and the defendant, while simultaneously saying we try people in a court and not on the internet. Those things don't go in the same sentence. This is not real. This is real. I mean, I know I see it. I can see it with my eyes. My brain is not processing this right.
The internet has no rules of evidence. The internet has no punishment for perjury. And the internet does not know all the facts. Conspiracy theories are not evidence. The idea that multiple police department, EMTs, fire personnel, the medical examiner, and prosecuting agencies are joined in or taken in by a vast...
Oh, we're just going to go right on in there. We're just going to go right on in there and opining. Oh, yep, we're going to do all of this.
Opining that the defense theory is garbage.
Yep, we're going to offer all the opinions. We're going to do that, and we're going to do that with our full chest. Holy shit. This is... Whew. Oh, this hurts my soul. Oh, this hurts my soul. Whatever I had left. Holy crap. This is uncomfortable. I am uncomfortable. This is
Vast conspiracy should be seen for what it is, completely contrary to the evidence and a desperate attempt to reassign guilt.
Oh, I'm sorry. There it is. It came further. I didn't realize we could keep going that far. Huh. Huh. So, minute and 44 seconds. Minute and 39 seconds. Minute 38 seconds. We can do this. I can do this. I can do this.
Michael Proctor, the state police trooper, being accused of planting evidence outside 34 Fairview Road, was never at Fairview Road on the day of the incident.
I fucking lied. I can't do this. What? I'm sorry.
You'd be getting punished for this.
Incident. Proctor and his state police partner traveled together the entire day while other officers were processing 34 Fairview. Trooper Proctor was not there and did not plant evidence at 34 Fairview Road. In addition to...
Wait a minute. Correct me if I'm wrong, but isn't that factually inaccurate based on what was presented at the first trial? Didn't he get the call while he was coming off shift and actually went to 34 Fairview? Or did he not go to Fairview? Am I misremembering the facts?
I don't remember.
I seem to recall rather specific testimony that he was coming off shift, but then got a call that there was a circumstance that required him to stay on and to redirect him, and it took him to 34 Fairview, the actual scene where it was taking place. That was testimony elicited at the first trial. So this statement isn't just opining on the credibility of witnesses. This is an inaccurate recitation, a complete inaccurate recitation of the facts that were adduced at trial. Proctor did not go to Fairview. Did he not go to Fairview? I'm seeing people that, we went to the hospital, not Fairview. Okay. If he went to the hospital and not Fairview, that might make this statement possibly true. Like I said, I might have been wrong. I'm speaking on my recollection of what the evidence was. But why are we opining on any of this as the prosecutor prior to this trial? Why are we talking about this? This shouldn't be happening. This just not. This is all before trial. And why are we talking about
this? Is so bad.
You cannot get up before a trial and say this officer is 100% truthful. Morrissey just placed Proctor's truthfulness at issue in this trial by this statement. If I'm the defense, I'm going straight to that and saying they want me not to bring up bad character evidence. He put this in the public record. This is insane.
To having no opportunity to plant the evidence, as has been suggested, Proctor would have no motive to do so. Trooper Proctor had no close personal relationship with any of the parties involved in the investigation.
Okay. So let's say I might have been wrong with the prior statement about him being there or not, even if I was wrong. I don't know if I was. I know for a fact that that one was a lie. Proctor knew everybody involved in this. That was brought up in direct examination by the Commonwealth because they knew it was going to get brought up by the defense. Oh, no wonder they got the phone. Yeah, this would have given me access to the phone in 2 seconds.
And had no conflict. And he had no reason to step out of this investigation. Every suggestion to the contrary is a lie.
Well, there's some more opinions on the credibility of certain testimony before a trial that shouldn't be made. Do we have a running tally of the violations here? This is fucking insane.
This should be seen for what it is and not used as a pretext to attack and harass others. What is happening to the witnesses, some with no actual involvement in the case, is wrong. It is contrary to the American values of fairness and the constitutional value of a fair trial.
Okay, so here's the thing. Harassing witnesses is bad. I don't like it. I don't like some of the stuff I've seen of people approaching witnesses and trying to cross them and all this stuff. I don't like that. I don't particularly care for that. That's not very fun. But, sir, let me rewind and make sure that I heard what you said right. Hang on.
Some with no actual involvement in the case is wrong. It is contrary to the American values of fairness and the constitutional value of a fair trial.
See, you said it's contrary to the values of fairness and the constitutional value of a fair trial. The constitutional value of a fair trial that is supposed to be preserved by prohibitions on pre-trial extrajudicial statements like this. This is the antithesis of upholding those values. Wow.
It needs to stop now. I am releasing this recorded statement rather than holding a news conference because my remarks need to be so narrowly tailored to the issue at hand while the prosecution is pending in Superior Court. But the message is the same. What is happening to these innocent people, these witnesses, is wrong and it needs to stop.
Oh my God. That was a whole ass dumpster fire. I don't know. I mean, I don't know what was worse. The beginning, all the middle parts, or kind of the end, where he openly acknowledges that he's narrowly tailoring his statement because of an active prosecution that's ongoing in the Superior Court and the right to a fair trial and all the things. And when he says that the credibility of these witnesses is beyond reproach and all those things. Huh. So while I emotionally process what I just watched, I'm going to go back to this, which is a pleading, because it makes more sense to me than what I just read or what I was. So here's, well, I also kind of find it kind of funny that this is filed by the district attorney who's like, please don't call me. Like Michael Morrissey says, please don't call me. I still don't know if that statement means that he has any evidence that either directly or indirectly proves or disproves Karen Reed's innocence, except for, with the exception of any statements he made that might have been factually inaccurate and where he got the information that he was conveying. I think that might have a loosely attenuated connection to either proving or disproving innocence or guilt on the part of Karen Reed. I don't know if it gets you over the hurdle of calling him. So, I don't know if that changes my opinion. It certainly has me reconsidering whether or not he has any information that might be relevant. And this question, Natty Mom, the state bar and the body politic who votes him into office. I don't know where the state bar is on any ethics stuff, but that's...
State bar almost never goes after prosecutors.
No, because they're usually pretty cozy with the people on the review panels, generally speaking. Look at Tom Girardi. Let me give you a perfect example. Look at Tom Girardi, who's not even a prosecutor, but someone who had political power. Not saying that Morrissey's anything like that. Just saying, I don't know. That's... Dude, if I'm a judge and I see a prosecutor making that statement, my head is in my hands and I am just bashing my head against the desk.
No, your gun is in your hands.
Well, no,
metaphorically.
Metaphorically. Well, that's a thing. Guess we'll see that play out. It'll be very interesting. Motion limited to allow counsel to state grounds for objections and promote judicial economy and efficiency and adequately preserve issues. This was one that I think 10 out of 10 Coyote is going to deny. But I can see why defense wants to do it. Every lawyer wants to be able to state their grounds for their objection so the jury can hear it. Now, 2 reasons. 1, you want to state your grounds so that you are sure the judge is ruling on the correct grounds for your objection. Because the judge, you might say objection. The judge might be speculating that your objection is on the basis of hearsay, right? But you could be objecting on the basis of relevance or best evidence rule or something like that. So when you're just saying objection and you're not allowed to state your grounds and the judge summarily says overruled or sustained, you're not creating a very clear trial record, because when you go to the Court of Appeals and you say, I appeal because of this decision, Court of Appeals says, go ahead.
They specifically cite case law too. Case example here.
Where you have to be able to say your grounds, right?
Where the defense failing to say what grounds there were,
you waived the appeal.
Ended up costing them the appeal. Yep.
You waive that issue on appeal. And this is one where judges and lawyers get in some consternation. Actually, a trial I had a little bit of back and forth with the judge that became very tense, where the judge said that there were objections that I should make and objections I shouldn't. And he was inferring that the objection I was making was one I shouldn't, because I should trust the trial court. And I was like, Judge, I trust you. But that's not my job. My job isn't to trust you.
The thing is, what I would tell the court on this one is just, listen, if you don't allow us to say objection hearsay, literally everything will be objection sidebar.
And you have that right. And this is where, if Bev pushes back on this, you have the right to make your record. You absolutely do. So you can make that record on every objection
sidebar.
Yep. And this is what you do. You make it very clear to the judge. Judge, if you don't let me say a word, and there's a flip side to this one. Let's say you agree with the Commonwealth that, and the judge tries to strong arm you, because that's what happens too. Judges try to strong arm you. They're like, we're not going to allow any speaking objection. You're like, fine, judge, I'll just object. Or that you say objection and the judge admonishes you for saying like objection hearsay. So the counsel, you don't need to state grounds. At that point in time, I immediately ask for a sidebar and I say, Judge, I need to state grounds. And the judge says, no, you don't, counsel. And I say, well, this is going to be a very, 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 very long trial. And then you take the trial hostage. It's the one tool you have. And it's one of those where you kind of dare the judge to deny you the ability to state your grounds or deny you sidebar. And at that point in time, you just keep objecting and you keep making the request, even though it's denied and denied and denied. And the judge eventually gets the point that they're going to get their ass overturned on appeal. So I think that the way that Canoni did it in the past, I hated, because I hated the idea of just stating objection and not allowing. And here's, some judges will require you to say the rule, right? I've had that case before where the judge is like, counsel, you can say the rule, but that's it. That's fine.
Oh, that would be difficult because I'd have a hard time remembering them. I'd have a little cheat card.
But you'd have your cheat card and you'd get used to it and you'd anticipate it pretty quickly because you're so used to objection, hearsay, not offered or not subject to an exception, or hearsay clearly being offered for the truth, not being offered for a permissible purpose. You are able to articulate them usually pretty quickly, and if you had the rules in front of you, you could probably do that pretty quick. I mean, it wouldn't be hard to adjust within a trial. You'd adjust to it pretty quickly. Oh, the statement. We'll get to that in a second. Motion for order prohibiting the Commonwealth and its agents from speaking with or having contact with any other witnesses once they've taken the stand. This should be just. This one should just be like the response to this one should just be consent. Agreed. Yeah, it should be.
I mean, this is the sort of thing where you get that like request and you're just like, your response is just, regarding, this, I wouldn't even put it, it would just be like for, motion, whatever, we consent. I'd probably just do, we consent to the following motions. Like, these are all fine.
Well, the question is, if you're going to respond to this and object to it, what are you going to say? How are you gonna say that, no, judge, I should totally be allowed to talk to witnesses? I mean, I guess you could say that you need to tell them to navigate pretrial rulings and motions in limine. But maybe Brennan gets to talk? No, I don't like that either. No, it should just be a blanket rule. Fuck it. You cannot give me a justification that would, once you've taken the stand and started testifying, you don't get to talk to them. Defendants, motion limited to exclude false and irrelevant statements of Michael Proctor. Oh, this is the car. This is a school thing, right?
Yeah, this is the school thing.
I was harassed. All right, so this is going to get argued again. Motion limited to exclude irrelevant, inadmissible, and prejudicial prior bad character and propensity evidence. Didn't she file one of these under seal? Oh, this is going to the Aruba incident. Yeah, this one bothered me too. The Aruba stuff. Why are we allowed to get into that? I don't see that the Commonwealth has really created a nexus. I get their point. There's a breakup imminent, that this was anger, animosity, maybe a connection, but the question is, how much prejudice are you inviting by allowing testimony of this? I don't know. Bev's going to let it in, though, because she let it in the first trial. I imagine a lot of these are just pro forma. Defendant's motion for reconsideration of the March 6th order denying the motion to exclude testimony of Commonwealth's witness James Crosby. So, Dr. Crosby, we're going to reconsider. We're going to ask to reconsider this. But before that, hang on, let me do this because there's a lot that I have to play catch up on real quick. So, there's been a lot of questions about this, and I really want to make sure I've got it. Peggy Reardon, what's the between a regular motion and a motion in limine? Motion in limine is a motion asking the judge to make a pretrial ruling on a piece of evidence that you intend to adduce at trial. So, judge, either bar it or admit it, but give me a pretrial ruling on the evidence so that I know what I can do. Question: how would they bring up Proctor's lie about Yannetti from the first trial and the second trial? They're asking to preclude it. I don't know how they would bring it up unless it got in, unless Judge Bev denies that motion. My question, so from Maya: hi, Robin Runkle. My question is, can a higher other court step in and override Judge Bev? It seems like the whole state is working against Karen. Not really.
That's what appeals courts are for.
That's why we talk about the appellate record and maintaining it. But appeals are, I mean, you've seen it. They're difficult to win. They're not cases. You don't want the case to be heard by an appellate court, because appellate courts, they don't like making hard calls. So you want the judge to get it right in the first instance. And as far as people's perception of the fairness of the judicial system, when it comes to certain cases, this is why it's important to watch cases. It's why it's important to see how the case works and proceeds and moves. So that you can offer an opinion in the future, whether it be the election of judges, prosecutors, county clerks. So you can opine in the political process to try and change the system going forward. It ain't pretty, but it's the system we have. The Squirrel, thank you for gifting memberships. Deanna Rufino, finally popping in for a live update that my divorce is almost official. I started a new business. The house is officially only in my name, and I'm so glad my company offers legal insurance.
That is awesome.
That is awesome. Congratulations. On to the next steps of your life, and may you live them happily. Like I said, I don't like the term "the best revenge is a life well lived." I just think the best way to get beyond a difficult time is to live a happy and good life.
It can often be great revenge, because the other person, if they're petty enough to be upset by it, which they usually are.
Yep. Oh, I just said that sometimes we don't really want revenge, so to speak, but if we did, that's the best revenge is life well lived. So live that life, make it your own, make yourself happy. Techno Stacy, question: is this your report? Answer: Bart Simpson voice. I didn't do it. Greg, okay, Rob, stop now and watch Morrissey's PR statement. I did. I didn't like it. I really didn't like it, but I did for you guys, and mostly also for me. K-Rab,
did you
Trooper
notice
Paul,
that all the books in the background were
out of order?
Out of order?
Yeah, I did. Yeah. Also, I wonder when the last time those books were ever opened. We don't
never.
Look at books.
Those are decorative ones.
They are. We don't look at those books anymore. Actually, that's not true. I will bring the code section or code books from time to time.
Code books, yes, like the criminal code, like the annotated criminal codes are useful.
Yeah, but case books, no.
Yeah.
K-Rab, Trooper Paul took a 3-week course which taught him how to put numbers into formulas. He was told that John was hit by a car. He pulled that formula. No thought was put into the scenario that made sense. Yeah. I'm inclined to agree. There wasn't a whole lot of logic placed into how he did the mathing, and the mathing didn't make sense. Lynn Britton, if it doesn't change your opinion, I'll be surprised, and where the video he references. I don't know that it changed my opinion. I think it made me view that there's some potential avenue of getting information out of him. I don't think it changed my opinion on whether the judge is going to grant it. I think it's going to get denied because there's some other avenue of getting the information. So that's my opinion on that. Gen V, the hostage video was so bad in his instance. All I hear is he doth protest too much. Methinks he is too insistent. He's opining on the credibility of witnesses, which you cannot do. Mama bets they are emails from him to the judges and witnesses. Well, that's fascinating. Did we have those during the first trial, or were those discovered after the fact? Because that's a lot. I don't like this trial. I've never liked this trial. I'm so uncomfortable with so much of what happens in here. Greg, the hostage video is one of the things that firmly put me in the conspiracy camp. I was on the fence until I saw this. That's the other part about it. This is also why you're not allowed to do that.
Great job with that, huh?
Yeah, this is also why you're not allowed to do that, because you persuade the public on the veracity of certain claims. You're not supposed to do that. Like you said, D.A. Morrissey. Guilt is adjudicated in trial, a fair trial, not on the internet. Ugh. Steve A., how do you know they didn't commit a crime? Your supposed police department didn't even investigate. It's interesting. Brooke Dragon KSC question: would this be an extrajudicial statement? Isn't this what the Commonwealth is mad about the defense for? Like exactly, but worse, because this is the prosecution, which is subject to different rules because they're the prosecution. Lynn Britton, you have now 100% entered the upside down. Apparently, I'm not sure I like it here. Mrs. Squirrel and the Commonwealth wants a gag order. Haha. Yeah. Here's the secret. Every prosecutor wants a gag order after they've made the statements that they've made, and to prevent everyone else from saying that it's par for the course. It's not a surprise. Every prosecutor wants a gag order after they've had the bully pulpit in their possession and control for the weeks leading up to the trial. Shay B, while watching hostage video, Flabber has been gasted. Yes, the Flabber has been gasted. AG got 8 hours of independent steno practice in today. Congratulations. Absolutely in love with steno. Also, the statement currently being read is breaking my brain. It shattered mine. So I don't understand how that happened. Or anyone who's an associate DA or an assistant DA in his office didn't run up to him and say, so hang on, here's a thought. What if we didn't do this? Just say it. Shay B, does DA Morrissey still have a job after all this? Oh yeah, he's got a job. He very much is. Techno Stacy, is he on the witness list? For right now, he is. Michigan Farm Boy, the message is the same. It's okay if we don't, but we'll attack you if you do. And try to jail you for it. Morrissey basically kind of like, our witnesses are right. Your witnesses are our statement, our narrative is correct. How dare you question it? It would be, shameful for you to question the veracity of witnesses ever, especially when they say what we want them to say. I don't like any of that. Lindsay, been a while since we were on track to have Rob streaming up until after 2 at his time. We're close. It's nice. Well, nice is subjective. SF, what do you think the defense did when they saw the Commonwealth video? Shit a brick. That's what I think. I think a brick was literally shit. I don't know by whom or how, but in no world would I ever foresee that possibility happening. Prosecutors do some things. That was a whole other thing. Like the Koberger statements by the prosecutor were questionable, very questionable. But the Koberger statements, remember that argument in front of Judge, they were saying, well, we basically just read the probable cause affidavit. And you look back at the statement, you're going, yeah, you went a little bit beyond that. And even Judge was kind of pointing that out. And that was bad. And that resulted in the gag order, like saying, we're not going to do this anymore. Morrissey's statement was 9 million times worse. I don't know if there's a number how many times worse that was. Purple Dragonair, bold of Morrissey to claim that witnesses are truthful when the factual proof Higgins lied on the stand. There was a lot of statements in that just don't ring true. Sandie, thank you for gifting memberships. Kelly, if Chloe bit, you must acquit. Love the name. He emailed judges ex parte with personal email to scold them for denying the Commonwealth's protective order on Turtle Boy.
Wow. If I was the judges, I would be like, okay, you're going to come into my courtroom to explain yourself.
Bev denied removing him from in that office, but skeptic Hank decided he's going to go through the emails himself and not the taint team. I am uncomfortable. Remember the whole thing we've been talking about in prior cases about the mere appearance of impropriety and how we try to avoid that, like at all costs?
They're well past. They've blown past appearance of impropriety.
We forgot about all the rules. We're in different territory. This is Mad Max shit.
Just gonna step away a moment here.
Yep, but Septic Hank decided he's going to go through the emails himself and not the Taint team. Mm-hmm. That's where we are. We're here. But how? Like, how? Shabby, Ian brought the books to the background. Now I can't unsee it. There's a lot of things I wish I could unhear and unsee about that video. I might have to watch that again, like after the stream, just to make sure I heard everything right that I heard, because I don't feel like I did, and I'm confused. Alyssa, does anyone know why that statement for Morrissey is just now coming out? Why wasn't it brought up in the previous motions, or did it? I don't know. I had not seen that before. I know that people in the chat were saying it's been talked about recently by Peter, lawyer, you know. I don't know why I hadn't seen that before. I don't know when it came. Melanie Little apparently talked about it a couple days ago. But that video was published August of 2023. It was out in the public. It was known in the public for that time. I don't know why. I don't know why it took so long for that to be mentioned. Oh, so Asher Jones is saying it did come out during prior to the first trial, and it was Unity was big mad about it. That's astounding to me. That is astounding to me that would be played. I cannot fathom a world where I want my elected prosecutor doing that. Under no circumstance would I ever want that. It was horrible. That's horrible. I mean, imagine that you live in a jurisdiction. Do you want a prosecutor doing that? Under any circumstance, regardless of what's happening in the public eye? You allow pundits to go out there and say that. You allow people that are champions for your cause to go out there and say, you don't say it yourself as the elected prosecutor. Just astounding. Greg is making this comment in response. So, Greg, thank you for Alyssa's question. They did bring it up in the last trial. They didn't have any of his personal emails to back up calling him as a witness then. The personal emails, I am now very intrigued about. I haven't seen those. That argument is going to be fascinating. I imagine there's going to be I can get why a judge wouldn't recuse himself for simply you can't get a judge recused for simply that judge receiving an email, right? If you were to create a rule where a judge had to recuse himself for receiving an email ex parte from a prosecutor, then the prosecutor would just send an email to every judge that they did want having a case heard. So you can't create that rule. But why there wasn't an admonishment on the record, sanctions or something that came down because of that, I don't understand. That part's very confusing to me. Purple Dragon, I hold a graduate degree in math, and Trooper Paul's use of formulas broke my brain. People need to understand that computers are only as smart as the people using them. Purple Dragon Air, if you go back to any of the videos that I did when I did recaps of Karen Reed, there was a certain day where Trooper Proctor was testifying to the speed the vehicle had attained going backwards and in reverse. And it did not make sense to me. The feet traveled and the speed the vehicle obtained going in reverse. It did not make sense to me at all in any sense. So I took my truck and I actually went to a parking lot and I actually threw it in reverse and tried to hit that speed. And full pedal to the metal, couldn't do it in the distance that was being said. So I'm sitting there going, how does Karen Reed's SUV do that? I understand it. Not in the snow, not on the curve, not on other things. There was a lot that was left out in the simple math application that, for me, made Trooper Paul lose 100% of his credibility. I don't know if it was brought up properly in cross. I think it was crossed pretty well, but I think the defense needs to do a better job of destroying him. I don't think they're going to call Trooper Paul. I think you have a new expert. But
they have Trooper Paul on their witness list.
No.
I'm not kidding.
Well, we get to listen to that shit show again. Maybe it'll be better. Maybe he's had 2 more hours of training. Grace's mom, Rob's there's video of Morrissey that states Karen Reed is guilty. Jury just hasn't figured it out yet.
Wow.
I can't remember if it was before the hostage video, but he said that. That is fucking amazing. I can't believe that. That's not a world I want my prosecutors living in. The Southern Mom, thank you all both for the best severe weather anxiety distraction. Hope everything's staying safe. If you're in the path of the storms, please stay safe, everyone. If you are in the path of any storm, regardless of where you are. Bolshevik Muppet. Melody Little released emails related to this video. I'm going to have to go check that out. Greg. Also, Morrissey's emails and texts were set to auto-delete after 30 days. Coincidentally. When you're in a state elected office, you shouldn't have auto-delete emails ever. That's my opinion. When you're a state agent, you shouldn't have auto-delete emails ever. Actually, Linnell, Colleen Crawford and John Fanning started an editing software company with Bev's neighbor, dissolved it a day after Karen's arrest. I know there's a lot of interplay in this community. I'm trying not to read into it because I don't know enough about it. Kelly, if Chloe bit, you must quit. They used it before the first trial to try and have Norfolk DA's office thrown off the case, but Bev denied. The email info is in the Badero letters. Okay, I will check it out. Burberries. Keep in mind, Morrissey is the same DA who declined to press charges in Birchmore case because they found no wrongdoing. Hence, it's only federal. Oh. Rob, Ian, have you ever had a judge recused? Recusal happens more often than you would think.
I've had judges recused, but not for anything interesting.
That part. Yeah. Yeah. I've had a judge recused because they knew their kid played on the same soccer team as the kid whose custody was in dispute. Like I've had a judge recused for stuff like that. Or they were friends with,
I had one that was literally, we get up there, it's trial day, and the judge says, well, we've got a problem. And it's like, what's the issue? And the judge is like, I used to be his lawyer.
Yep.
Can't run the trial today. So we're like, okay. So we just got a new trial date, and that was it. Because, yeah,
it happens quite often, but not for the reasons that you're thinking. Okay, let me see. We'll pull this back up. All right, so the motion to reconsider for Crosby, the March order. The crux of this is basically what we were all saying. You held Dr. Reed to a standard that required 2 days of a Daubert hearing, and you barely let her in, but you let Crosby in on some bullshit. And very rarely will I say that a motion to reconsider has any chance. I don't know. I think if anything, then maybe the judge would reconsider a Daubert hearing. I don't think she will. I think she's going to stick by her original opinion. That's just my gut. But it's worth a shot. We'll see how the witness presents at trial. I am largely in agreement with any of the logic here because I was pretty frankly astounded that Crosby got in the first place. Just my opinion.
I don't like Crosby is just such obvious evidence of bias. So yeah.
I know. It was that last hearing where I kind of really started the benefit of the doubt that I was kind of giving Judge Cannoni started slipping and slipping, and I'm now struggling very much with this case in general. That's the thing. It's without assigning any true opinion as to Karen Reed's guilt or innocence, like as to whether she actually factually did anything. I hate the way this trial is going forward and how disparate the standards are between prosecution and defense. So on that note, there was a gag order entered that said, nobody shall talk about the trial. Thou shalt shut thy mouths. And shortly after that gag order was entered, this statement got released. Michael Proctor's family released a statement accuses Karen Reed of maligning embattled trooper. Oh, they chose quite the picture for him. Who is this that published this one? This is Boston.
Believe it or not, that's actually one of the better pictures of him.
That's sad. After exhaustive investigation at both state and federal level and a grand jury, only one person has been charged with the crime. The defendant, Karen Reed, the trooper's wife, said. So, I am now reading this statement with a new context, and that context is Michael Morrissey's published remarks. So that actually might color my view of this, because I've read this before, and I might actually have a different opinion about this now. The family of embattled Massachusetts State Police Trooper Michael Proctor, whose crude texts about Karen Reed cast a pall over the first murder trial and put his own career in jeopardy, has spoken out for the first time after the judge's gag order. Proctor's wife and sister released statements Thursday accusing Reed's lawyers of maligning the investigator to deflect from, quote, overwhelming, end quote, evidence pointing to Reed's alleged role in January 2022 death of her boyfriend, Boston police officer John O'Keefe. So let's go ahead. Where is the statement? There we go. Original formatting. This is the statement. This is from, now, mind you, this is from, quote unquote, Proctor's wife and sister.
Sort of.
Because they're saying it's from Proctor's wife and sister, because if it's from Proctor, Proctor is an agent of the state rather than the Commonwealth, and Proctor is subject to the order prohibiting extrajudicial statements. So Proctor can't say these things, but his wife and child, who have independent capability and say what they want, First Amendment rights, they can say they're not subject to the gag order, technically, are allowed to say what they want to say. However, how much of this statement is truly from Proctor's wife and child versus from him or Morrissey, which I'm sad to say I now have that thought entering my brain. In light of the egregiously false statements from Karen Reed and her defense team, both inside and outside of the courtroom, Michael Proctor's family is speaking out for the first time to address the ongoing misrepresentation of his character and calling for the public to actually look at the facts of the case. On January 29, 2022, 14 minutes before his on-call shift was due to end, Michael Proctor was assigned to an unattended death case, and his life was forever changed. Proctor and the other investigators followed the evidence, and a jury of the defendant's peers indicted Reed, and only Reed, for the murder of Officer John O'Keefe. Despite this, the family says Michael Proctor has been defamed, maligned, and falsely labeled corrupt by alleged murderer, her family, her defense team, and a mob of her followers. I am not a Karen Reed follower in any respect, but I don't think Michael Proctor is a person I would want to police. Through unrelenting propaganda and disinformation, the defense is trying this case in the court of public opinion and painting Karen Reed as the victim with the hope of tainting the jury pool.
They write with the hope of tainting the jury pool?
Publicly. Yeah, I know. At the end of the day, a beloved police officer and honorable man was killed. The prosecution believes it's an open and shut case, and the defense knows this too. So their tactic is to put my husband, the lead investigator, on trial for sending texts on his personal phone to his friends and family. Oh, honey. That's from the wife. The Karen Reed defense team is unabashedly creating false narratives and distracting the public and potential jurors from clear-cut evidence. So you're speaking to the potential jurors and the public too?
Mm-hmm.
It was recently announced that all aspects of the federal investigation involving the case has been closed. Michael Proctor, who has an unblemished police record, has 12 years with Massachusetts State Police.
Who's facing
what?
Massive disciplinary proceedings.
Testified that his texts on his personal phone were unprofessional and regrettable, but certainly didn't affect the integrity of the investigation.
What are they doing? They are affecting the integrity of the investigation.
I'm going to say, like, that can be your testimony, but it doesn't mean I have to believe it. Michael and so many others, and this is a quote, Michael and so many others in his line of work see horrible things every day and may at times need to vent personally. I get that. I do the same. I'm a lawyer. We lawyers have very dark humor. Very dark humor. We have to. We see a lot of shit. He saw a fellow officer die a horrible, tragic death. Who among us has not said something regrettable in moments of stress, shock, and sadness? I get that 100%. I get it 1,000%. Don't try to tell me that the statements when going through the phone and talking about Karen Reed's physical ailments and whether or not there were nudes in the phone you were going through is you saying something regrettable in a moment of stress, shock, or sadness. And how would you feel if the contents of your personal phone were questionably released to the public without full context? Questionably released is that's a phrase. Without full context, I'll give you that. I will give you that 100%. Proctor's sister says, like, full context, great. You know what provides context? The whole messages, all of it. But you don't want that out either. Wife says the family's been tormented for years because of the case. It's time to focus on the real perpetrator. See, can't really do that. That's unfortunately, we know that by speaking out, more harassment will be unleashed on our family. I don't want that. I don't. I hate this crap. We can no longer stand by and silently watch Michael's character be attacked and disparaged so unfairly. My question is, why are you releasing this statement on the literal eve of trial? We are 2 weeks out from trial. You couldn't have released this statement like post first trial. You know, intervening months.
Oh, they're releasing it on the eve of trial because they're trying to taint the jury.
After the jury was impaneled and the trial was ongoing, and you say, oh my God, I can't believe they went after him that way. So continuing with the quote, after exhaustive investigations at both state and federal level and the grand jury, only one person has been charged with the crime, the defendant, Karen Reed. Okay. Here's the thing. I don't know if there's the thing.
You're like, no, it is crazy. No,
this is crazy. This is. I buy that an eighth of this came from the family. That's what I buy. The rest of this is just, it has this feeling of attempting to bypass the gag order 100%.
Oh, I suspect, but I don't know. My suspicion is that Michael Proctor was the author of this thing.
I don't doubt that. And you don't want to go like trial within a trial and like start going down some ancillary matter, but if I'm a judge and entered an order that I expected to be followed, I'd be pretty fucking pissed reading this. I would look at Michael Proctor, and you better fucking believe I'd have some stern words for him, and just basically saying, you're telling me with a straight face that you had no knowledge, input, or discussion with your family about releasing this, and the fact that I had entered a gag order preventing anybody from talking about this case prior to this statement being released? Like, do you not talk to each other in the same household?
I don't know. It's crazy.
January Garnet, do you think the appearance of bias is worse now the federal investigation is over? No, I think the appearance of bias is pretty consistent. I don't particularly care for a lot of it. I think the federal investigation being over has very much, look, the people on either side of this case, Karen Reed is guilty, Karen Reed is innocent. The people that are on either side of this case are, I don't know if I can say dug in, because is there a way of saying dug in that's more than just dug in? Like
barnacle.
immune to any statement that might be contrary to the verbatim 100% position advanced by their side of the aisle. You cannot convince a single human in the Free Karen Reed camp that there's any possibility that Karen Reed did what she did or did what she's alleged to have done. Similarly,
I mean, yeah, it's just nobody's moving on this one.
No one's moving. No one is
and the
moving.
Thing is
it is. Yeah.
The evidence isn't getting any better either way, so.
Which is why I'm so confused on. I don't know. If you have the public at large who is viewing this evidence and you have about a 50-50 division in whether people think she's innocent or guilty, do you think as a prosecutor you should ethically bring a case that you think you can prove beyond a reasonable doubt? Do you think you can prove a case beyond a reasonable doubt when half the people are adamant that this was not done and half the people are adamant that this was done? To me, that is just right there. I don't think I can prove that case beyond a reasonable doubt because the people that are at my body politic, the people who I answer to as your population, don't know whether it happened or not. So I'm torn on this. No, I'm not torn on this. I don't think there's any chance they get beyond a reasonable doubt. For me, understanding how that standard is supposed to be applied.
I mean, the thing is that the jury may not end up seeing any of this stuff.
No.
So,
and that's properly so in some cases, in some instances.
I don't know. Except in this case, it might be that they don't get to hear the third party defense and so forth.
I know. Or they hear about a dental impression of some dog somewhere that we think is this dog, and they're going to hold it up to a picture and say that that's clearly bite marks, or I don't know. This case has been an exemplar of the vast power of the state in prosecuting a case. For anyone who ever listens to me talk about how the state has immense power and holy crap, you don't want to end up on the wrong side of that system, here's your example. I mean, this is your example. Here's a good one. Why won't Rob admit that Karen is innocent? Because I wasn't there. And I have a very, very hard time saying affirmatively that something did or did not happen when I didn't see it with my own eyes. Because I'm a fucking skeptic and a lawyer that's seen a whole lot of shit.
And that's the thing, is a trial can change rapidly at any, at any point. So, you never know.
Yeah. And that's the thing. Innocent and not guilty are different things. Yeah, not guilty. That's where I am. That's where I am. I'm at not guilty. It's where my head has been. And I have seen way too much change in trials. And I've seen way too many people testify one way or the other. I've seen people testify that were 1,000% believable. 1,000% believable. Where it later turned out they were completely full of shit. So
I've had clients that I was sure they were innocent, that then it turned out I was wrong. And I've had the reverse, where there was clients who I thought was 100% sure they were guilty. And it's like, well, they're guilty, but they deserve a defense. And then I go and run the trial, and I'm like, holy shit, they're telling the truth, right? So, yeah.
So I am that you cannot prove beyond a reasonable doubt. People are saying, what do I actually believe? I actually believe that a vehicle doesn't do what was testified to. I believe that Trooper Fall, I don't believe that testimony. That's what I don't believe.
I mean, the thing is, I don't believe the Commonwealth theory of things.
Yeah.
Right? So that's, I can't say what happened, but I certainly don't believe their theory. There's just too much wrong with it.
Mm-hmm. There's too many holes. Too much reasonable doubt. That's right there. And sitting there staring you in the face. So that is where I am with this trial. Okay. We catch up on this, and then I've got one happy thing before we head out. Lisa says, sorry, pocket parts were inserts from my law books before computers. Oh, I know what you're talking about. The annotations that we would add inside the statutes every year. Okay, my job updating our books with paper pocket parts. I'm so old. No, I get it. I used to get those every year. Steve A, undermine attorney credibility equals career limiting.
Yep.
In response to Janet, Kate may be.
I mean, theoretically, a lawyer should never be getting that kind of finding against her. It's insane that a lawyer, that's becoming a thing, right?
Mm-hmm.
So.
Yep. Kate Maybe says, love seeing the ADHD in full swing. Never related so much to listening to Rob while doing work. I can see myself in Runkle's face. That's the ADHD focus face. Yeah, we both do it to each other too. Like he'll be talking, I'll be doing something on the side. It's relatively common. PJ Wolf Weimers, been here longer. Never for 3 months. Thank you. Quinny Bly, woohoo, caught the live before you finished. Hugs. Thanks, Quinny Bly. Glad to see you. Angie, Janet sued Lily, Jesse, Becca Day, and Kitty in the same suit that Lauren sued Becca Day and Kitty. All but a defamation claim against Lily were dismissed. For those of you wondering what more.
But some of the claims were dismissed without prejudice, which means they can bring them back.
Refiled. So
some of those, I mean, a smarter lawyer would drop them, but Janet is not a smart lawyer. I'm not even sure she's smart by hamster standards. So, yeah.
Possible. Annabelle Feinstein, over 2 years. Wow, time flies. Glad to see you, Annabelle Feinstein. Okay, so the last thing I wanted to end with, let me do this. We'll do one last swoop. One last swoop. And what we have is just a video that Sandie, who's in the chat, asked me if I would mind playing. Should be loading. Let's see. Load. Load. You can do it.
And that made the chat very angry at me, because the chat is saying that I am being very unfair to hamsters, and they're ready to go to war on behalf of hamster kind here.
On behalf of hamsters?
Yeah. They're saying it's very unfair that a hamster would get compared to Janet.
Well, I will say this, that Sandie, I'm going to blame you because your video and uploading the video is freezing StreamYard. So I'm going to do this.
StreamYard seems to be having a weird problem with videos right now. Wait. That apparently killed Rob. Okay, so welcome to the Runkle Show. Hi, folks. I apologize because I have no plans for tonight. So we're just going to wing it. I hope everyone is having a wonderful evening. I'm like, what do I do? Do I pull up a video game here? I'm like, So I assume Rob is coming back? Oh, there's a Rob. What did you do, Rob?
I was StreamYard was not loading the video, and then it froze. I tried to bring it back, and it was like, you have to wait for the page to refresh. I say, no, I'm not doing that. And it was angry at me. So let's see. Let's see if I can do this. Or present it as the window. Let's see. Can you guys hear audio? Hear it? Yes? No? Well, either way. So there's Sandie. Well, everyone's mad there's no audio. Dang it. We'll do it this way. Let me see if I can share it as a tabby tab. So for those of you ever curious about Sandie, and Sandie did give me permission to share the video. So you can't yell at me about that. There, this should play.
Y'all, I'm here with somebody who wants to say hi.
What up, everyone? Law and lumberites. I think I just made that up. Law and lumberites. law and lumbernesses. Sandie's right here in Las Vegas. We just finished the Shin Lim show. What'd you think?
It was wonderful. Everybody needs to come see it.
Thank you so much. I'm glad you had a good time. These guys, come check it out. And then you get to hang out with me like this. And you don't have to be jealous of Sandie anymore.
So that's fun. Sandie got to do that. And oddly enough, I couldn't say it earlier because the Mischiefs might have been watching, but the Minis might have been watching. But I'm going to be able to head out there because I had a trial get continued. So I can create a small window of time when I can head out there and see Spidey. So while he's still in residency in Vegas doing his show. So no, you did not just get renamed. You guys are still Sparkle Farts, the Lumberites. I don't think the Lumberites make any sense. You guys are still Sparkle Farts. But that was the positive note that I wanted to leave everyone with because you know what? Crazy cases are everywhere, but y'all somehow always band together and create a pretty good group of people. So cheers to all of you for being here. Cheers to the mods. Thank you for the time you gave, the time you continue to give, all the sharing and love you share in the community. Thank you for everyone for being here. Ian, you're doing your show on Monday.
Barring some sort of chaos, yep.
Well, chaos seems to follow everybody all the time. So.
It does, but here's hoping.
You know what? And at the rate these documents keep dropping.
Oh, fuck. I mean, at least the last one was like there was a deadline, right? So a whole bunch of stuff happened all at once. So, yeah.
Are either of us streaming KR gavel to gavel? I cannot. For those of you who do not know, I am a full-time practicing lawyer that has trials and all of the above. So I cannot stream it, and so is Ian. I know that Emily does a lot of live streaming for trials. I imagine she is streaming this trial in particular. Peter will likely be doing recaps. Ian will likely be doing recaps. I will try to do recaps when I can. There's going to be enough content with this trial that you're going to be able to find a lot of people doing an analysis of it because of how wild so much of this stuff is. Usually. Analytical Blarney AB. Sandie is a boss. Support the mods, guys. Yes, please do. Send them some love. Give them some love. Okay. So, Andrea's doing it Gavel to gavel. So is Melanie. Okay. There you go. Bunch of options. Emily, Andrea Burkhart, Melanie Little. A lot of people that you guys can follow on the trial. It's going to begin April 1st. I believe that week of April 1st, first week of April. And then we'll go from there. Okay, folks. Oh, yeah, Recovery Addict too. Why did I even say that? Yeah. Scott, Recovery Addict. Yeah, he'll stream it as well. All right, folks.
I mean, there's just going to be so many freaking good options for that. So
this is a trial that I remember last time when I was covering it. I would watch the trial, and then during the weekdays, I would be in the shop listening to recaps of people going through different parts of the trial and parts that I missed or parts that I thought were important. This trial is fascinating to me. And I see why a lot of people are very invested in it. So we'll see when it comes up. Thank you guys for being here. Much appreciated. Thanks for spending the time with me. We're going to finish just under 5 hours. Enjoy your weekend. Hug the loved ones. Get outside. Get in the shop. Get in the art studio. Make something. You'll feel better. And I will see you the next time. Bye, guys.